of K. Bender Rimbaum's Orlando office. A little bit about the firm. We've got offices in Pompano Beach, Palm Beach Gardens, Tampa, here in Orlando, and then also in Miami by appointment. We're 21 attorneys, 8 of whom are board certified in community association law, 1 of whom is board certified in construction law. And really all we've done since the 1990s, I won't say me personally, but the firm since the 90s is represent community associations. Occasionally we've taken on individuals and groups of individuals, but the reality is 99.9% of what we have done and what we do now is representing community associations as general counsel. We can basically handle any issue that comes up that a community association might want to handle. And that includes, like I said, some of the construction defect issues that come up, although we do partner with other firms occasionally if that becomes necessary. Any municipal issues that the association encounters, anything. I'm not going to waste your time going through the list, but if it pertains to your community, it's what we do. So we'd be happy if we're not already working with your community. And if you're on this call and on the board, I'd be happy to meet with you at your convenience. My email address is right here. It's as@kbrlegal.com. That is almost always going to be the easiest way to reach me, whether I'm in the office or not. I do get those emails. Can't promise to respond if I'm not in the office, but I will at least see and acknowledge those within 24 hours. I respond to everything I get from clients and potential clients. So moving forward, enough of that spiel. We thank you for thinking of K. Bender Rimbaum for your educational needs. And when I say needs, we'll get into what that might mean if some of the current condo bills pass in just a moment here. But we hope you will think of us if you do have those legal needs and either you're not 100% satisfied with your current counsel or you don't even have an attorney, which some communities might.
Folks, little technical issue there. I've got Alan coming back in as a panelist. That was a little technical snafu. Sorry about that. Alan, you're back.
That's okay. Listen, I understand you guys have heard enough about the firm. You want to get the education. So you do have 2 options, at least as of right now. There's a bill that is floating through the Senate and the House right now that if it's adopted would require you to do both of these things. But as of right now, you have the option, and you chose the right option, to either take a class like this and give the certificate to your secretary or your manager within 90 days after being elected, or up to a year before you're elected, or you can just sign basically something that's completely lying, saying you've read all of the association governing documents, you'll work to uphold them to the best of your ability, and you will faithfully discharge your fiduciary responsibility to the association. Now, I say this is a lie because let's be realistic. The fact that you've read through your governing documents means nothing. Okay, you haven't read through the statutes because this certificate doesn't require that. You haven't understood the governing documents. You don't know what to do in the event of a conflict. And that's part of why you have an attorney. But you won't know an attorney is needed unless you've taken a class like this and hopefully listened to what I have to say today so that you can learn a little bit about what you need to know and what you should know. And frankly, where you should be acknowledging that it's not your responsibility to know certain things. It's your responsibility to get good guidance from your professionals about those particular issues. Now, the problem with the certification is that if you say you've read the documents and you're going to uphold them, I've actually seen people hauled into court to testify, and this was in an unrelated matter, but as an association director, the truth of what you are generally going to say, your propensity for lying gets called into question. Your credibility gets killed. If you're sitting here telling people, yes, I've read the governing documents, I'll do my best to uphold them, and then people ask you questions about what's in those governing documents, and you can't answer them because you have no idea. And I'll be candid. I have represented communities for 15 years or 13 years who I have no idea what's in their governing documents. Okay. I've been in this industry since 2010, did mortgage foreclosures before then. Some of these communities I've represented on and off for years, and I don't know what's in their documents because it's not that I don't understand it. It's not that I don't read it. It's that it conflicts internally. The documents are generally poorly drafted. So that's why I spend so much time amending them, not only to make substantive changes, but so that they actually make sense. So bottom line, you're doing the right thing. I'm preaching to the choir a little bit here, but I would strongly suggest that you get all of your directors to take this class, just so that they have the education that you will now have by the end of today. The certification doesn't have to be repeated, meaning you don't have to take this class again, but keep in mind that is set to change if some of the current bills go into place. But as of now, you don't have to take this class again unless your service on the board is interrupted, meaning you are actually removed from service or you resign. So it's you are if you're just suspended from service, and we'll get into what might happen to cause that later. That does not require that you retake this course. The written certification needs to be retained in the association records for 5 years after the director is elected, or the duration of the uninterrupted tenure, meaning if you're on the board for 8 years, it stays in the official records for 8 years. It can be removed once you're no longer on the board. If you don't have that written certification or the educational certificate that you'll get after today's class, which Jeff will go into later, not having that on file doesn't impact the validity of any board actions that are taken. In other words, if you voted on something, but you weren't certified or the certificate simply wasn't included in the association records, no harm, no foul is basically the way that the statute looks at that. Condominiums only really exist because of enabling legislation. They're governed by Chapter 718, which is what creates condominiums, other than your declaration of condominium. This form of property ownership wouldn't exist without the statute. You're also, keep in mind, subject to Chapter 617, which is the not-for-profit statute. Now, there's going to be probably some co-ops that are on the line today. You guys are pretty much going to operate the same way. There are little differences, but hopefully if you have an attorney, they can tell you what those are. If not, you're welcome to reach out to me if you've got a situation that you're not sure if the condo statute works differently, and I'll be happy to try and help you out. The declaration creates title and also contains your covenants and restrictions. So when an HOA refers to the CC&Rs, that's what your declaration of condominium is doing. The condo wouldn't exist without the statute or the declaration. All of the owners in a condo own an undivided interest in the common elements. That's another distinction between an HOA where the corporation owns it, owns those common areas, and a condo where the owners actually own the common elements as what's called an appurtenance to their unit. That doesn't mean that you're able to go and take away the common elements from the association. It means that you've got an interest in those common elements versus, again, the corporation itself wholly owning those common areas. The association has a bunch of powers and duties. Okay, the association's responsible for the operation and affairs of the condominium. What does that mean? You're maintaining and operating a corporation and a building or several buildings and any of the amenities that are included, the easements, and literally anything else that's included in the association property. There may be limitations on that. For example, what's inside the units usually is not something you can control unless it's impacting something outside the units. But this association, the corporation itself, and by the way, corporation is what you are running. You're running a business if you're on the board. Okay, that corporation is responsible for the maintenance and operation of the entire community. There's a bunch of powers and duties listed in Chapter 718, which is the condo statute, 719, which is the co-op statute, and 617, which is the not-for-profit statute that the association has. I'm not going to go through them in detail because, frankly, most of them just make sense. You can sue and be sued, purchase real property. You might need a 75% vote or another vote, depending on what's in your documents. You can do all of these things listed in this slide as an association. And that makes sense because you have to have the ability to operate and maintain the community. So we move on to, okay, well, I mentioned that the governing documents are generally not written in a clear manner unless you've had them amended by someone like me or our firm. Then the question arises, okay, well, if we have the governing documents, we also have the statutes, which one controls? And that's going to be decided not only as to which one controls, but which year's statutes control, by some case law that's come out in Florida. The first thing that we want to talk about is the Constitution of the state of Florida. The law that's in effect as of the time of a contract is grafted into the contract as though it were written into the contract. The contract we're talking about here in a condo, at least for purposes of today's class, is the declaration itself. Because understand, your declaration is not just some document. It is literally the Constitution, and there's Florida case law that uses this exact term. It is the constitution of a mini government. Now, you are not a government entity subject to government regulations as a government entity, as a condo. But I use that word to explain a little bit more of how important this declaration is to your community. Now, moving forward, the actual state constitution and the U.S. Constitution protect people and protect individuals and corporations from retroactive application of laws that impact the substantive rights that everyone has under that contract. So if you've got a vested right that is impacted by a statute, that's going to be treated differently from some procedure that doesn't really make a huge difference as to your rights. It's just going to change the operation of the condo. So if there's a new penalty, if there's a new obligation or duty, and if there's a vested right that's affected or destroyed, that's going to be a substantive change in the statute if it's amended. Now, there's this language that we look at in the declaration, and I know that for now, you're probably sitting here thinking, oh my God, he's covering 10 topics in 5 minutes. How am I ever going to get all of this? Understand that Jeff will ensure that part of your completion of the survey, in addition to getting your certificate available on your screen, you're also going to get a copy of my materials from today. So don't think that you have to sit here and take notes. I usually mention that up front, but you don't have to write down everything I'm saying. The other thing I'll mention is this class will be available online within the next few days. So if you need to go back and refer to what I said because you didn't get it down and you want to be the person that takes 150 pages of notes for 170 slides, have at it. I'm just letting you know in advance that's not necessary. So going back to what we refer to in this industry as Kaufman language. If the declaration provides that it's subject to the Florida statutes as they're amended from time to time, then what you're saying in your declaration is that this document is intended to apply any change to the Florida statutes. If you've got that language, then this year's statutes apply if the statute controls over the declaration. If you don't have that language, then your attorney, and I say your attorney meaning your attorney, not you. The fact that I'm explaining this doesn't mean that you are qualified to make the determination of what law applies, but it's so that you understand a little better. Does the legislation itself say that it's retroactive? If it doesn't, it might not be, and it might not be intended to be retroactive, which means you might not have a retroactivity problem. If it doesn't clarify, are the changes substantive or procedural? Like I said earlier, procedural changes to a statute are generally going to apply to the association, regardless of the intent to have the original statute apply. Substantive changes, meaning you're changing rights, and we'll move on to the next slide, which I think, yep, it clarifies exactly what we're talking about here. Those changes of vested rights, there is a due process requirement that be included in the declaration to be impacted. So you would need an amendment to your declaration for a new law to impact the association and impact your rights as an association or as a unit owner. So in other words, if the declaration has this Kaufman language as amended from time to time pertaining to the statute, then all the changes apply regardless of whether they're substantive or procedural. If there's no Kaufman language in the declaration and it's procedural change, which again, your attorney should be advising you on, not you making the determination. But if it's procedural in nature, meaning you have to do X to have the election go properly, things of that nature, then the new statute will apply over the old statute. If it's a substantive change and there's no Kaufman language, old statute applies. So I talked about conflicts. Those don't only exist within the same document. Sometimes there was an amendment to the declaration, and for some reason the attorney didn't read the bylaws to see that the bylaws say something completely different from what the declaration was changed to say. Okay, the answer to these problems is amend everything to be clear as to what controls. If you haven't done that, or like many communities in Florida, you simply can't get the vote to get an amendment passed, then what you will look at is you'll look at the order of importance of your governing documents. Now, remember that old expression, a little dab will do you? Well, we're looking at declaration, articles, bylaws. That's the dab. Okay, my kids talk about a different kind of dab. It's this thing. I prefer to avoid ever doing it or talking about it, but I've been told that that is a more modern explanation. But anyway, the declaration, we talked about what this is. It's basically anything that's in there is going to be given credence by a judge, unless there's Florida case law or federal or state law that says you are legally not allowed to have something in your governing documents. Okay. That's the case unless you are also arbitrarily enforcing these provisions of the declaration differently with one member compared to other members of the community. Your articles of incorporation are next in line, meaning that if there's a conflict between the declaration and the articles, your declaration is going to control. And I apologize for tripping over my words a little bit. Like Jeff mentioned, I already did a 1-hour webinar about an hour and a half ago. So I'm going to do my best here. So the articles are basically going to be a document that says the name and purpose of the corporation and very little else. Sometimes it'll be who the board members are and things of that nature. The bylaws are what most people think is your document that says everything about how the community is run, but it's really just your day-to-day operation. It controls how meetings are run, directors and officers, who they may be, what their obligations are, etc. And then you've got finally your rules and regulations, which are generally going to be board made without member approval, which means that they're scrutinized a lot more closely by the courts. So that's going to go in the order that I just mentioned them as to which one takes precedence. Your declarations first, then your articles, then your bylaws, then all the other stuff that the board has cobbled together. My suggestion is to have a single set of rules, regulations, and policies, and to amend that set when you are making changes, rather than just having 20 different rules, which I've seen many communities have, and having people have to try and look at, okay, well, is there even a rule about this? Put it all together in a single document. And that includes your policies that I think every community should have, governing collection of unpaid assessments, covenant enforcement, records inspection requests, and member participation at meetings. I think every single one of those 4 policies, which I prepare for communities as a batch, like a flat fee type of project, I think every community should have that. And it's the first thing I recommend for every new client I bring into the firm if they don't already have something like that. I think that's important to have that and have it compiled together with the rules and regulations so that everyone's looking at the same document and it's only one document plus the amendments to those documents, just like your declaration, articles, and rules and regulation. And your bylaws. Moving forward, transfer fees and estoppel certificates is our first substantive topic. The association can't charge a fee in connection with the sale, mortgage, lease, sublease, or other transfer of a unit unless the association is required to approve the transfer and the fee pertains to the actual application process. That fee is limited to $150 per applicant, and no other fee can be charged by a condo. Whereas in HOAs, you see a lot of capital contributions and other types of charges. Those are considered against public policy of Florida because, frankly, it just makes it harder for you to sell your property. And Florida law wants you to be able to sell your property however you want. You're living in a condominium, and as a result, you are a little bit more regulated than other Florida properties. So just keep that in mind. A security deposit is different. It can be required if the governing documents authorize you to charge that security deposit. Some considerations when you are, and this is usually going to be in a move-in, move-out, or construction context where you're going to have that security deposit. You're not a landlord for the most part. So that security deposit is something that you want to make sure your governing documents are also clear as to who gets that money back when the security deposit is refunded. Because a lot of times you'll have a security deposit that tenants have to pay, that has to be paid in connection with construction, and you'll have competing claims by the tenant and the landlord or by the construction company and the owner as to who's supposed to get that money back. And if you don't have that in your documents and it's not clear from the documents that you've prepared who gets it back, you end up having to spend a bunch of attorney's fees filing what's called an interpleader lawsuit, where you're depositing the money in a judge's registry and saying, court, you hold on to this money and let the judge make a determination of who gets it. But you've already had to go to the extent of filing a lawsuit and having a judge dismiss you from that lawsuit after going out and serving all the parties. And it's just a huge expense that shouldn't be necessary. So just a practical tip. Moving forward, we talked about security deposits. Leasing is another reason, if it's authorized in your governing documents, that you can charge that kind of application fee of up to $150. When you get a request for what's called an estoppel certificate, this is basically a document that says what's owed on the property, what assessments are coming due during the time that that estoppel certificate is going to be valid. And it's a document that just contains a bunch of information that someone's going to rely on in order to close either a transaction, which is usually a sale of that unit, or is going to lend money on that unit in reliance on what you're telling them needs to be done in order to bring that unit up to a current state, meaning all assessments are paid, all covenant violations have been resolved, etc. There's additional information that goes into this. We do have an entire list. Most of the time, it's not going to be send me an estoppel certificate. It's going to be fill out this form that I'm asking you to fill out. You might need to have your attorney take a look at that to find out whether you have an obligation to complete all of the information that's being requested. Most management firms and most individual directors who are self-managed will just go ahead and fill out whatever's been requested. But if you're not 100% sure, you really should be reaching out to your attorney to find out whether this is information that this individual who's requesting the estoppel certificate is actually entitled to. The certificate needs to be produced within 10 business days after receiving a written or electronic request from an owner, mortgagee, or either of their designees. Meaning you need to provide this document within 10 business days after someone asks for it. If you don't get to charge any fees for preparation of the estoppel certificate. And there's some legislation being pushed forward now, which I hope won't go through, that actually says you might not get anything that's owed, and you might not be able to enforce any violations if you don't produce the estoppel certificate within those 10 business days. So bottom line, you should be making sure that you're complying with that timeline. Your website, if you have one, needs to designate someone with authority that it will receive those estoppel requests and deal with them. They must be completed by a board member, authorized agent, or authorized representative. Usually that's going to be a director, your manager, or your attorney. They must be provided by hand delivery, regular mail. I've never seen anyone do it by either one of those, or email on the date of issuance of the estoppel certificate. I have seen a couple faxes here and there. That's also allowed. And the certificate must be signed by an officer or authorized agent of the association. Basically, the person that's allowed to prepare it can also sign it. Now, one thing that I'll point out is anything that's not in this estoppel certificate that's going on this property that's not included, you're basically waiving it. So if you've got attorney's fees because an account's in collection, you need to make sure that your management firm is shutting off access to that ledger, that they are reaching out to counsel to get a payoff rather than providing a payoff, so that all of the attorney's fees and costs, if you're under our collection program, we haven't charged any of those fees and costs to you because we're holding off until that file is closed or paid in full in order to charge anything. We basically, we incur that fee and all of those out-of-pocket costs, except for a small nominal fee every year in exchange for us doing the work for you. The bottom line is you won't know what those fees and costs are. So you're not going to include them. If they're not included and the owner closes on that transaction, those fees and costs are wiped out. So I know that's a lot of words to say, make sure that everything's included, but there are a lot of pitfalls here. And you want to make sure that either the board, if the board is preparing this, or management, if management is preparing this, is fully aware of everything, not just what's in the association records, but everything that should be going into this certificate. So moving along, here are some of the contents of what should go in here. We've got 170 slides. I don't think I need to read this to you. So I will skip some of this information. We're allowed to do that, and you can still get your credit. So don't worry that I'm skipping things and you're going to have a problem and you won't get your certificate. We're the ones that provide it. We know what we're allowed and not allowed to do. some of these things in here are pertinent, but you might want to read through this list at some point in the future. And I apologize. There's going to be a bunch I have to skip today. But again, 170 slides, 2.5 hours, and we do want to get to some Q&A. So I might skip a bunch more than I'd like to, and it might be also more than you'd like, but we'll get through it together. There are fees that are set by the statute and subsequently by the DBPR. This is changed every 5 years. There is a bill that's going through the legislature now that you can't charge this fee to the requester. That doesn't mean that the person preparing the estoppel certificate isn't still going to charge the association. So just be aware for now, you can charge the fees that are listed in this slide and the next one. That changes every 5 years, and it's done by the DBPR. It won't be done again until 2027. Again, if you deliver this late, you cannot charge a fee. If it's requested within 3 business days and provided within 3 business days from the date of the request, that additional rush fee can also be charged. So just be aware also, you need a resolution of the board in writing in order to charge this estoppel fee. That's something that we can prepare for our clients. If you have other counsel and you don't have that resolution in your association records, I'd strongly suggest that you prepare it. The alternative is that if the management contract calls for that fee, which it probably does, you're also covered there. Now, the other thing that I've seen in practical context is someone claiming that if the estoppel isn't provided in time or it's not provided within an unreasonably quick time, that they'll lose the sale and they'll try and hold the association responsible, or if information in there is incorrect. I've never seen that claim succeed. I'm not saying it won't, but just understand these are people that are just trying to push your buttons to get you to respond quicker because they screwed up and waited way too long to request the estoppel. Because keep in mind, I customarily will see these requested 4 to 5 business days before a closing, often 4 days before a closing, not business days. And you've got at a minimum, even if it's requested on a rush basis, 3 business days to produce this. So when you get someone contacting you the day before a sale saying, I need an estoppel, your response can be, we'll get it to you as soon as we can, but just understand, you had to request this at least a couple days ago to get it to you immediately. Moving forward, I'm going to skip the fees on multiple parcels. We already talked about the adjustment that happens every 5 years. These estoppel certificates are good for 30 days if they are delivered by email or fax. 35 if sent by mail. Again, I don't know anyone that mails these out. You may have requests for other information that isn't included in the specific statutes that are talking about estoppel certificates. That's a separate issue, and there is a separate fee that is associated with it. If you get a request that isn't for an estoppel certificate and it's in connection with a closing, it's something at least the first 1 or 2 times that you get those types of requests, just run it by your attorney. But just know the Condo Act does allow you, allow others, including mortgagees and other prospective purchasers and lien holders, to ask for additional information. Usually that's going to be Fannie Mae, Freddie Mac, other lenders, etc. And also you can put in your response, which generally, again, will be your attorney responding to those requests, that the responses are made in good faith to the best of the respondent's ability as to their accuracy. Putting that in there basically limits the liability of anyone that's producing this estoppel for purposes of liability. So you're basically saying, well, I did what I could with the information I had. So you're basically hedging yourself a little bit there. Your condo question and answer sheet is something that needs to be updated annually. It's basically issues pertaining to your community in particular must be provided to prospective purchasers by the association. Now, the seller is the one that has the obligation to provide the buyer notice of all hidden defects. In other words, if it's obvious, then you don't have to produce any kind of notice about it because they can walk in and see it. If it's something that's hidden, the seller needs to provide notice. Now, if the association knows of a problem, that might still be something that goes onto an estoppel certificate. Now, speaking of construction defects that might impact this, just so you're aware, one thing that we didn't mention here is that as of July of this year, the statute of repose, which is basically the time frame when you can actually file a claim for a construction defect, has been reduced. It was 20 years, then it was reduced to 10 years. As of this July, it'll be reduced to 7 years. So if you've recently turned over control of your condo, you're going to want to make sure that you get an engineer in there and have them take a look and make sure that there are no defects that need to be addressed by the builder. If that's not an issue that you're comfortable handling on your own, finding the engineers and working with them, we do have, like I mentioned earlier, a board certified construction attorney in-house. So that's something we can work with you on as well. Unit owner disclosures prior to sale. I'm not going to go through all of this because frankly, it's things that the seller has to do. The governance form is another one. Seller's obligated to disclose, seller's obligated to disclose, and we can move on. Now, again, I'm skipping a bunch. I fully acknowledge it, but we've still got 150 slides to get through. So moving on to use right suspensions, voting suspensions, and fining. I don't like fines because they don't get you anywhere. They get you, hey, you owe me some money. In a condo, you cannot lien for unpaid fines, which means you can't foreclose for unpaid fines, which means that the only way to actually collect those fines is to file a claim for damages, file a lawsuit and say they owe me $800 for unpaid fines. So you're going to spend way more in attorney's fees than what's owed in the fines. You're also not getting your resolution, which is to have the owner cure whatever the violation was that caused the fine in the first place, if all you did was levy a fine. So again, covenant enforcement policy should be put into place, and you should be pursuing either an injunction or forcing the owner to otherwise stop doing what they're doing that they shouldn't do. Now, I say the owner, whenever I say that, it's usually in a covenant enforcement context. That's going to include any tenants, visitors, etc., to that unit. So jumping off that soapbox momentarily, for anything other than to pay a monetary obligation, the association has the right to suspend use rights. Whether or not you have the right to suspend voting rights of a member, meaning that at any vote that the members are allowed to vote at, your election meeting, amendments, things of that nature, you're allowed to actually suspend the right to vote of any unit owner if your governing documents allow it. There's case law that says your governing documents must say that you have that right to suspend voting rights. To suspend the right to use common facilities, meaning your gym, your special clubhouse rooms, your pool, things of that nature, that you would generally have the right to do, whether it's in your governing documents or not. That said, there's nothing that says you shouldn't put it in there if you're already working on amendments to your declaration. A fine or use right suspension for that is not for non-payment, meaning it's for violations, cannot be levied unless the board first levies the fine or use right suspension. Basically, you have a board meeting with normal notice of a board meeting, but mentioning that this is something that's going on the agenda, and the owner is aware of the violation as a result of that notice, and has then an opportunity to attend a separate hearing in front of a fining or suspension, or I like to call it just the violations committee, no sooner than 14 days from the date of the notice. So you've got a three-phase plan here when you're talking about fines or suspensions, at least for violations. First, you're going to send notice that the board is going to meet. The board's going to meet and decide that, hey, this is bad enough that we should fine and or suspend this person's use rights or voting rights. Second, you've got a separate committee of individuals who are not directors, are not officers, and are not their family members, and are not the manager, who are going to decide, and it's at least 3 individuals, they're going to decide whether to complete the fine, suspension, or whatever. If they vote no, the fine or suspension doesn't pass and you start from square one. If they vote yes, then the owner gets notice that the fine or suspension has been passed and that they have an obligation to either pay the fine or cure the violation before that suspension will be lifted. So again, you've got a board meeting, you've got a violation committee meeting, and there used to be a question as to whether you had to provide that meeting or actually hold the meeting. You have to hold that meeting. Then you provide notice saying, hey, this is due. You have to pay the fine or you are suspended. The maximum fine is $100 per violation per day of a continuing violation, up to $1,000 total. So I want you to understand, you're not sitting here and you're going to make it $50,000 in a condo. What you might be able to do is compile 8 different violations and go after $8,000 worth of damages. But frankly, from my perspective, you're better off just enforcing, spending your attorney's fees there, and trying to get the actual resolution of the issue itself. Another thing that I'm suggesting, and I'm working on 6 or 7 of these right now, is to amend your governing documents if they don't already say, and almost none of them already will say, that the owner who causes, or the owner of the unit who causes the violation and doesn't cure it, is responsible for all attorney's fees and costs incurred in enforcing that violation as an assessment against the unit, regardless of whether a lawsuit is filed or not. What that's going to do for the association is, instead of this being a cost of doing business, meaning your attorney's fees and costs, you basically don't really expect to recover those in a community association enforcement context. Now, all of a sudden, you're treating that as an assessment, and you're holding the individual that caused this problem responsible for the costs that are being incurred by the association, rather than the entire membership bearing that cost. So moving along, I've covered most of this. Okay, the fine that you have now passed is due 5 days after the committee meeting at which the fine is approved. This is another thing that the legislature is looking to change this year, but as of right now, this is the case. Use right suspensions for failing to pay monetary obligations for greater than 90 days is the other reason that you might suspend use rights or voting rights. So the board in and of itself gets to decide. This is not separate voting by a committee. This is the board in and of itself in a single meeting can adopt a use right suspension or a voting suspension if you have the ability to do that for non-payment of an assessment, or other monetary obligation for at least 90 days. Now, in order for that suspension to take effect, you do need to still give that notice to whoever's responsible for whatever that monetary obligation is. It's effective until that monetary obligation is paid in full. So if someone owes $10,000 in assessments, interest, late fees, attorney's fees, and costs, they pay $9,999.99. That suspension doesn't need to be lifted because they still owe that penny. As ridiculous as that may sound, we'll get into later. And I do have a completely separate covenant enforcement class that you're welcome to check out on our website, or the collection class that you're also welcome to check out on our website. Those are all recorded just like this class will be recorded. And that's not me trying to drum up business. Just understand we don't charge for any of these classes. But there's a lot more detail in those that I don't have time to get into now. The bottom line is the suspension is effective until the monetary obligation is paid in full. And that goes by the statutorily required order of how you apply payments that are made by an owner. That's going to be first to interest, then to late fees, if any, then to attorney's fees and costs, and then to the assessment. What that means for practical purposes is that penny is actually a penny of assessments that's owed. They didn't pay off the assessments. They paid off the interest and all those other charges first. Moving along, the suspension applies to everyone that pertains to that unit, not just the unit owners. While the association can suspend the right to use common elements, the suspension doesn't apply to limited common elements, meaning you can't tell someone you can't use their unit, you can't enter the unit, you can't suspend common elements needed to access it, utility services. And a lot of people ask whether that includes internet or not. Frankly, my perspective is if that internet is being provided by the association, there is a likelihood, if not, certainly not a definite, but there is a likelihood that a judge might find that that is a utility. There's nothing that I'm aware of that definitively identifies that as a utility, but there is not Florida case law that's binding precedent, but there are arbitration decisions. We'll get into what that means later, which means that if you end up in arbitration instead of litigation, which may be the owner's option, then you may end up dealing with a situation where even though Florida law doesn't say that's a utility, it's treated as a utility for purposes of what we're talking about. So just be careful. Make sure that if you are going to suspend, that you have a form notice of suspension that your attorney has prepared or at least approved, so that you know you're not suspending any rights that you're not allowed to suspend under Florida law. And if you are, then you've made the conscious decision to say, well, we think that there's a possibility that we're allowed to do this under Florida law, not just the board unilaterally deciding to do what it thinks is appropriate. I do use this suspension fairly regularly. I think it can be very valuable. The thing to keep in mind is that the likelihood that someone is not going to be willing, or no one is going to be willing to let these individuals into your gym, even though they've been suspended, is low, and they won't know that they're being suspended at all, or that they're being suspended because they're not paying their assessments that are causing this other person who's letting them in to pay more assessments down the road. So just understand the likelihood that it will be successful, but it's entirely feasible that it is, yes, you were able to suspend, but it ends up being kind of meaningless. But it's still worthwhile to do it, just to put these people on notice that they are further violating your governing documents and your directives in the Florida statutes if they do choose to use those amenities, despite the suspension. So to suspend voting rights, the delinquency needs to be greater than $1,000, and proof of that obligation, in other words, you need to give the opportunity for that person to pay it off, not just leave the account balance running, at least 30 days before the suspension takes effect. I mentioned this case law earlier, so we'll go back through it. Be careful what you wish for. One thing I haven't mentioned is that when a voting interest is suspended, that vote no longer exists until it's reinstated. So if you're trying to reach a quorum when you have a vote coming up of the members, for example, you're trying to get an amendment passed, and this is someone who might vote in favor of that amendment or even show up to vote so that you have a quorum, even if they're going to vote against it, you are now removing that person. So if you had 500, or I'm sorry, if you had 100 units in your condo and 5 of those members were suspended, you now have 95 voting interests for purposes of having a vote, reaching a quorum, having any, let's say you have an amendment that requires a 2/3 vote. 2/3 is 2/3 of 95 now, not 100. So it may make it more difficult. It can be a double-edged sword. And now we can move on to member meetings. So these are meetings, just so we're clear, because there's a lot of misunderstanding that I've seen, especially in attending board meetings. A member meeting is just one where the members get to vote on something. That's completely separate from a board meeting where the board gets to vote on things. So just understand who's entitled to vote for what, because I literally spent a half hour during a meeting about a month and a half ago explaining to an owner why she didn't get to vote at a meeting of the board because she was not a director. It was not a member meeting, but she's still entitled to attend a board meeting, which we'll get into in a minute. The annual member meeting is going to be located at wherever the bylaws say. If the bylaws don't say where that meeting is going to be held, the meeting must be held within 45 miles of the condominium property. The board's going to call the meeting however the bylaws say. Most likely that annual meeting is going to be governed by the Florida Administrative Code, and I'll go through what the procedure for that meeting is in a minute. The election is going to occur at or in conjunction with the annual meeting. You can also have special meetings, which is literally any other meeting that you hold throughout the year where the members get to vote. That's held whenever it's called by the board. The alternative to the board scheduling this is that a written request can be made by at least 10% of all of the owners, unless a different percentage is provided in the governing documents. Again, usually that's going to be stated in your bylaws if there's a different percentage. Now, your notice needs to be made in writing for this annual meeting. The agenda needs to be included with the notice, and it needs to be sent to each member at least 14 days in advance of the meeting. Now, that's for every member meeting. That's not necessarily for board meetings. This is member meetings. That notice needs to state the date, time, location, and the agenda, like I said, for that meeting. So for every single meeting of a condominium, you need to have an agenda. That doesn't necessarily mean that you're going to have a 20-page agenda, but every individual item that you intend to vote on during that meeting needs to be stated in the agenda. If it's not in the agenda, you don't vote on it. Now, there are things that you can do not to get around that requirement, but to take care of things. But that's really only for the board. The only alternative to having a meeting with an item on the agenda for a member meeting is to get a written vote of all the members instead of having them vote at that meeting. The notice needs to state the date, time, and location for the meeting we mentioned. Proof of that notice needs to be by an affidavit signed by the person that actually sent the notices out. You can provide electronic notices. whenever I talk about electronic notices throughout the course of today, and whenever you see electronic notices that are allowed to be provided in your condominium, just understand that is only going to apply to the individual owners who actually wrote to you accepting, and you should have a form for checking off that they accept and signing off. Only those owners that accept notice in that manner and have written to you saying, we will accept this, instead of written notice being mailed to us, only those owners who have accepted it are actually accepting notices that way, which means you may be emailing some people, but having to mail notices to everyone else. That electronic notice can't be used for recalls or retrofitting condos with fire sprinkler systems. That's just something we're required to mention. That unit owner is responsible. If someone says, I want to accept email notices because I don't want to have to check my mail, that's great because it saves the association postage and printing, and it also enables the association to get it to you faster. But that member is the one that's responsible for keeping the association updated as to what their mailing address is, what their email address is, and to make sure that they don't have their spam filter blocking whoever is sending those association notices. Once it's sent by the association, your obligations are done. Keep in mind also, member meetings may need to be held at a location that's physically accessible to physically handicapped people if they request it. So you don't necessarily need to have every meeting at a location where physically handicapped people can actually attend. But if they request it, you're going to need to provide that as part of both the Fair Housing Act and most likely the Americans with Disabilities Act. So bottom line, those are things that you don't want to mess with. And we do have an entire class governing those issues as well, largely in the context of having pets in the association versus having service and support animals. So moving on, quorums, decision, participation. A quorum of a member meeting, unless the bylaws say otherwise, the percentage of voting interest required to constitute a quorum is a majority of the total voting interest. Again, if you've got use rights, if you got voting rights suspended in your condo, that percentage may be smaller and it may be a smaller figure, but you've got less votes available. Unless, excuse me, the Florida statutes or the governing documents say otherwise, decisions that are made by the members need to be made by a majority of voting interests during a meeting where there is a quorum of members present. Members have the right to speak at member meetings with regard to all agenda items for up to 3 minutes. Again, this is one of the policies that you'll want to have in place, is how and when members get to speak. When we say they have the right to speak up to 3 minutes, you don't necessarily have the right to limit that unless you've got a written policy in place that says when and for how long these members are allowed to speak. So if you don't have that policy, get one in place as soon as possible. That's one of the first things, like I said, any new client that comes to work with our Orlando office of our firm, that's the first thing that I suggest after we get your governing documents ordered and compiled. Recorded meetings, a member can record or videotape a meeting. I recently had an issue where a member claimed that the association publishing to the rest of the membership a video of a meeting where that individual was shown on the video was an invasion of privacy. Just understand, if you voluntarily go into a meeting that might have 30, 40 people, chances are that's not an invasion of privacy because you had no reasonable expectation of privacy. So just understand, when you choose to attend those meetings via Zoom, that likeness is going to be something that the association's allowed to share, whether you like it or not. So if you're going to attend in that way and you have a problem with it, keep your video off. Pretty simple. Let's see. The other thing to talk about is closed meetings with counsel. That's a separate issue. And I guess, you know what, we'll wait for board meetings for that. You can vote by proxy. General proxies allow the proxy holder to vote however they want. A limited proxy lists the issues that the proxy holder can cast a vote for and instructs them how to vote. In other words, I am voting, but I can't be at the meeting, so I'm going to allow you to deliver the vote, or I'm mailing it in. In a condo, limited proxies must be used for certain things. It's basically anything that the Condo Act requires or permits a vote of the unit owners. I won't bother reading the rest. It's anything the members get to vote for. you can use a proxy, but it must be a limited proxy. General proxies and limited proxies can be used to establish a quorum. They just won't necessarily count for a vote if they're general proxies. For condo elections, no proxy, general or limited, must be used, but it can be used for any other voting at the meeting. Any proxy is only effective for that specific meeting and any adjournment of that meeting. Meaning, if you have a proxy that was used for this year's election, I hate to tell you, but that's not still good next year. So you have to have a new proxy form. And here's another reason. It's only valid for 90 days after the date of the first meeting for which that proxy is given. It's also revocable at any time at the pleasure of the member that executes this. So just understand, if you've allowed someone else to serve as your proxy and you've handed the association or handed this person your proxy form, you can revoke that at any time and go vote yourself. The membership meeting can be held virtually with members participating by means of remote communication. That is in chapter 617. So just understand that needs to be made by motion or resolution. It needs to be that the board made the decision that this is how we're going to operate, but it is something you can do. Moving forward, elections. So there's no quorum requirement for a condo election, but at least 20% of the eligible voters need to vote in order to have a valid election. So essentially, yes, you've got a quorum requirement, but it's 20% regardless of what's in your governing documents. The election process is regulated by Chapter 18 and also the Florida Administrative Code. Okay, the way that you're going to vote is by a ballot using an inner and outer envelope that's sent to the members as part of the second notice of the election at least 14 days before the election. The outer envelope needs to have the unit owner's name, unit number, and signature. That's to verify who's actually voting and whether they've submitted more than one ballot or more than one ballot has been submitted on behalf of that unit. We want to make sure that people aren't trying to submit 8 ballots when they only have one unit that they own and one vote. Okay. Now, keep in mind, if you don't need an election because, for example, you have 5 open seats and only 4 or 5 people are actually interested in running for the board, and only as of the date that you were allowed to nominate yourself, which we'll go through in a minute, only those 4 or 5 people are left on the ballot, you don't have to hold an election. Those people just become the directors. If they were already directors, they roll over for the rest of the following term if you don't have an election. If they are actually elected, then they have whatever term the governing documents say, because that could be 2 or 3 years or whatever it may be. But generally speaking, if there's no election held, the board rolls over. And again, that rollover is for 1 year, not the entire term. So the time frame, and I know that a lot of this is probably confusing to those of you who are attending this class for the first time. I get it. That's part of why I always offer, if you've got any questions, please, I genuinely mean it. Feel free to reach out. Let me know if I can help you understand any of this a little better. And I routinely will spend an hour or two responding to people who have attended classes like this and emailed me with questions. I can't necessarily spend an hour with each person, but I promise you I am accessible. So here's the timeline. We've got 4 deadlines here, and I'm just going to go through them very briefly. There's a little bit more detail here, but this is actually very simple. Condo elections are made out to be this super complicated process, but they're the easiest thing because they're all the same. Whereas in an HOA, whatever the documents say is what you do. Here, what we're looking at is 60 days before the election or longer, not less than 60 days, the association mails the first notice saying the election is going to be held on this date at this time at this location. That's the entire notice. Okay, that's the 60 days. Within 40 days before the date of the election, everyone that wants to be on the ballot needs to let the association know that they intend to do so. They need to get the notice to the association, and the association lets them know, yes, here's your receipt. We got your request. Now, if the candidate also wants to include an information sheet about their candidacy and why they think they do a good job, then within 35 days before the election, they have to get that into the association. The cost of mailing and including those one sheet information sheets with their mailing is borne by the association. The unit owners that are willing to serve on the board and volunteer their time don't pay the additional cost of mailing that to the members. And then finally, presuming that you even need to have an election because you've got enough candidates where you have, let's say in the instance I mentioned before, you have 5 positions open, but you have 6 potential candidates. If you have that going on, you need to hold your election. And within no less than 14 days before the actual meeting, like I said earlier, you send your second notice containing those inner and outer envelopes, as well as the ballot itself. So that's going to list all the candidates alphabetically. It doesn't say who's an incumbent. It just says, here's who's eligible based on the dates that they were required to nominate themselves and the fact that none of the few things that will make them ineligible apply here. Elections are cited by plurality of those ballots cast. Basically, whoever gets the most votes wins. It's pretty simple. Vacancy on the board that's caused by the expiration of a term is filled by an election. Okay, a vacancy caused by a resignation can either be filled by appointment or another election, but why would you want to waste the time and money of having another election when the board can just say, we vote to have John Smith join the board in place of whoever resigned? That's so much easier. It's so much less costly. All it requires is to throw something on an agenda and have a board meeting 48 hours later. Simple. I mentioned election by acclamation. That's where there's not enough people to justify having an election meeting. That's something you can report basically on day 34 before the election. You should know as a condominium whether or not you need an election because you'll know who's eligible and who's not. The official records, meaning literally every piece of paper related to the election, are kept at least 1 year from the date of the election or any continued election, or until the next election if that's a later date. Any challenges to the election process, meaning election challenges themselves, must be brought either in court or in arbitration within 60 days after election results are announced. Usually that's going to be announced during the meeting, but if it's not, it's the date that those election results are announced. Now, something that I've heard that's dead wrong, well, they didn't hold an election the last 3 years, so anything they did during those 3 years is invalid. Absolutely not true. Okay, again, you might not have to have an election. Even if the board did it wrong and stayed on, it's the members' prerogative to either recall those directors who are refusing to hold an election or raise a challenge to the fact that no election's been held or attempted. So the attempt, the meaningful attempt, is what matters. And even then, it's not well, anything they did during that time is invalid. It's, well, we're going to challenge anything going forward, not anything that happened going backward. So a candidate for the election is literally anyone who has timely submitted the written notice of intent to be a candidate. Anyone that wants to be a candidate must be eligible to serve at the time of the deadline for submitting notice. So meaning not later than 40 days before the meeting, the election meeting is going to happen in order to have their name listed on the ballot or serve on the board. Meaning if you don't get that notice in within those 40 days, you're off. You don't have a chance unless you get appointed later by the board that does get elected. Now, there are a couple things that'll make you ineligible. I mentioned that earlier. One of them is having committed a felony in Florida or any offense that would have been a felony if it was committed in Florida, being arrested and convicted, and not having your civil rights restored within the last 5 years. So if the election is going to take place, actually, let me backtrack a little bit. It's as of the date they seek election. So if the election is going to take place exactly 5 years and 1 day from the date that this person got out of jail, got their civil rights restored, and is moving forward with their life, then unfortunately, they're still not going to be able to serve because it's 5 years from the date that they need to be named as a nominee, meaning 5 years plus the 40 days before the election that you need to have provided your name and thrown your name in the hat. So the validity of, and again, we're trying to basically validate actions that the board takes. If you find out that someone was not eligible for this reason because they hadn't had their civil rights restored for 5 years, for example, because you don't actually do background checks in your community because your governing documents don't authorize it and you can't get an amendment in to try and authorize it, then any action that was taken by that director is still going to be valid. It's just that they get pulled off the board. Another reason that you might not be eligible if you've been suspended or removed by the division under the Condominium Act. In other words, someone filed a complaint with the DBPR and you were actually removed from office. If you're delinquent in the payment of an assessment due to the association as of the deadline to submit the intent to be a candidate, meaning that 40-day timeline, you are not eligible. And then in a residential condo of more than 10 units, spouses or co-owners of a unit can't serve on the board at the same time unless they own multiple units or there's no one else that wants to serve. And then finally, if you become more than 90 days delinquent in payment of any fee, fine, or other monetary obligation, meaning you owe any money to the association for more than 90 days during your term of office, even if that 90 days started before you took office, you're deemed to have abandoned your seat. You're off. That seat is vacant. Okay, so those are the reasons that you might not be eligible. Also, if you die before the election takes place, hopefully your community is not going to put you on the board anyway. Condo number of directors is 5, except a condo which has 5 or fewer units is 3. That's all unless the bylaws say otherwise. Your term for condos is going to expire at the annual meeting, and members can stand for re-election unless it's prohibited to stand for re-election by the bylaws. There are some, some examples of why that might not be the case. So for example, if you have staggered terms and your term expires in 2 years, obviously you don't need to be reelected. Your term's not over. There are now condo term limits. That was not adopted, and it's an 8-year term limit, meaning when I say term limit, just to clarify what that means, because I don't think I've said yet, it basically means that's a limitation on how long you can serve on the board consecutively, meaning you come off, then you can come back on. That's how I see people working around this. I don't necessarily like it because then it makes the term limit meaningless. But technically, if there's an 8-year term limit, you come off the board after year 7.5 and you are reelected in the next election, you've been off the board. This is a new term. Don't know what to tell you. But the director can serve longer than a 1-year term, but no more than 8 years in a row. And that technically hasn't kicked in yet because the statute didn't say it was retroactive and it just took effect. I think this will finally kick in 2026 because it's going to be 8 years from the date that statute went into effect. So if you've been in place 8 years as of 2026, I think it was July 1st probably, at that point you will need to step off and be reelected at the next election. Now, whether or not you can step off and be reappointed by the board, I'm not going to give an opinion on that today. We talked about condo co-owners, so moving forward. Okay, so this is the process for the actual election. You're basically going to verify with the outer envelopes, these are the ones that are written on, that each member who is written on it is actually eligible to vote and that they are not submitting more than one. So you're basically going to have a roster of all your unit owners and check off each one as you get their ballot. You're going to put that in a pile to make sure you don't mess with it. And then you're going to continue checking all the rest of them. Once you've gone through all those during the meeting, this is stuff that can be done before the meeting. During the meeting, you're going to have everyone basically reviewing the actual ballots. The way that you do that is you first open all of the outer envelopes and separate out the inner envelopes. There shouldn't be any markings on the inner envelope, okay? Because that's how you maintain anonymity. If someone writes on it, we want to be inclusive and we'll count that vote anyway. They've just waived that anonymity, okay? So that's the purpose of the inner and outer envelopes. You have a piece of paper inside an envelope, inside an outer envelope. The only thing that identifies who's voting is the outer envelope, which you use only for the purpose of ensuring that that vote is one that should be counted. If there are multiple inner envelopes or multiple ballots inside that outer envelope, you're going to want to check and make sure whether that owner owns more than one unit. If they do, then you're going to check off for those units as well. Okay, if there's more than one ballot included, more than one inner envelope included, you're probably going to invalidate all of those because you can't tell, and it's not up to the association to unilaterally decide which of those ballots the owner intended to count towards the election. Once you've separated out all of those documents, you've got the ballot sitting there and it's the only thing in front of you because you've put everything to the side. Again, you're keeping that in a box or somewhere because it is an election record of the association. Once you've got just the ballots, that's when you're going to have some kind of committee or a group that counts the ballots and counts who voted for whom. And that's how you decide who wins the election. So that's an election in a nutshell. We do have an elections class. That was the severely abridged version. My strong recommendation also is to move to close out the balloting at some point during that election meeting. If you don't do that, then someone could show up 3 hours after the meeting started trying to submit their ballot. And frankly, that is not something you want to have to do, to basically sit there all night and all day and wait for everyone to finish submitting ballots. You want to be able to finish that meeting at some point throughout the day. So moving forward, who are the officers? Basically, whoever the directors say the officers are. So the members get to vote as to who the directors are. The directors get to vote as to who the officers are. So just understand, the directors and officers are different people. The members are wearing a completely different hat. Those are just your unit owners. So there's 3 different categorizations that many of the people on this Zoom meeting today are actually wearing. You're wearing all those 3 hats. You're a member, meaning you own a unit. You're a director, meaning you sit on the board, you vote on things, you make motions, second motions, abstain from voting, whatever. And then you have the officers. Those are the individuals who have specific responsibilities under your bylaws, and they're going to be defined in the bylaws. Okay, in the absence of a provision to the contrary in the bylaws, the association only needs to have a president, secretary, and treasurer. Now, keep in mind that a lot of the tasks that are going to be listed in your bylaws as to what these individuals are supposed to be doing is actually going to be something that your manager is going to handle if you're a managed community. If you're self-managed, then those responsibilities will actually carry forth to those individuals who've been elected. The officers serve without compensation unless the bylaws say otherwise. So again, we are a volunteer board. Generally, they're selected by the board immediately after the election of directors. So that's why your agenda for your meeting is not only going to include an agenda for the member meeting, but you're immediately then going to have the board meeting, which is called the organizational meeting. That's really all you're doing during that meeting, is deciding most of the time who's going to be the officers. Directors can't vote by proxy or secret ballot at board meetings except during that meeting to elect the officers themselves. There's no prohibition against changing officers midstream, and I routinely use that for presidents who decide that they're authorized to sign whatever contracts they want, tell people what they can and can't do in the community, etc. Basically, when you see overreach by a president, the way to curb that is to have the board vote to change who the president is at the next board meeting. That person doesn't come off the board, but they can be, if let's say you have a 7-member board and you've only got 5 officers, that person can be removed entirely as an officer in the middle of the year. I mentioned directors can't vote by proxy or secret ballot. They can email. What they can't do is vote via email. So you can't make decisions via email as a board. Electronic voting is allowed. I'm actually doing a class on electronic voting in person in Orlando tomorrow. So if that's something you're interested in, we do have the election class. We talk about electronic voting a little bit. The most important advice that I can give when it comes to electronic voting is to understand that, again, just like electronic service of notices, it's only going to apply to those people that basically said, yes, I'm willing to vote this way. You promote it by basically saying, this is super easy. You can do it on your cell phone. You don't have to ever come to a meeting again. You can still have your voice heard. Okay, that is what, and also the association is going to reduce its assessments because you're saving money on all of these mailings that need to go out to the members. Okay. Again, it only applies to those people who agree to vote electronically. So I'm going to skip the rest of this because the bottom line is use a vendor that your attorney is comfortable with, who that attorney knows is going to follow these strict statutory requirements for what the electronic voting vendor must do. The board. This is really what you guys are here for today. Okay. You need to know everything you can about how to be a director. Here's the most important thing that I will say today. Okay. If you've been ignoring me, shame on you. But if you're going to listen to anything today and take anything away from this class, it needs to be this. The board of directors, each one of you as a director, owes a fiduciary duty to the members. And the meaning of that term, fiduciary duty, is you are legally obligated to do what's in the best interest of the association, even if it hurts you. Even if it hurts your best interest or your unit's best interest, you still have the obligation to do it because you are volunteering for a corporate position that is actually very important. The board makes most of the decisions on behalf of the association. So the good news about this is you're judged by the highest duty imposed by law, but under the lowest possible standard. Okay, I call it the dumbest person in the room standard. And that's no offense to any of you individually, but you're judged as a reasonably prudent person taking actions in the good faith belief that those actions are in the association's best interest. Now, if we didn't have such a low standard, no one would volunteer because you get sued all the time for breaching that fiduciary duty, right? But you are allowed to use your business judgment to make board decisions. They should be objective decisions, informed decisions, and to the extent required, you should be consulting with your experts, meaning your attorneys, engineers, architects, okay? If you rely on the opinions of those professionals because you've taken the time and frankly spent the money to get those opinions, you will be almost 100% protected as an individual. Now, there may also be insurance. I always joke that your second most important bill that you could possibly pay is your directors and officers liability insurance, which is going to cover the individuals for alleged wrongdoing as a director. The joke is that our bill is the most important one. But in reality, we do give more important advice than your D&O carrier. So there you go. But I really think that is extremely important. And frankly, if you don't have D&O coverage, I would not be willing to volunteer for any board of directors that isn't covering my interest, as most communities in Florida do. No compensation unless otherwise authorized in the bylaws, which I mentioned earlier, unless it's that you're actually doing work for the association. Now, keep in mind, and when I say doing work, in excess of just serving as a director. Now, when I say doing work, just understand that doesn't mean there isn't a conflict of interest. So you're going to have to disclose that conflict. There's going to have to be a 2/3 vote of the board of directors in order to go forward with that contract, rather than just a majority of a quorum of directors. And you're going to have to sit out and abstain from discussion and voting other than presenting to the board when it comes to the vote as to whether to use your contract or someone else's. We do have, yet again, a conflicts of interest class that you might want to check out, again, free, previously recorded on our website. And when I say check that out, kbrlegal.com under the resources tab is where you'll find all the previous recordings. It's under the videos tab. Again, the board makes most decisions on behalf of the association. What is a meeting of the board? What isn't it? Now, this is a point of contention for many, 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 many professional attorneys and other people in this industry in Florida. My personal opinion, and not necessarily even one shared by the board, and I know there are plenty of people out there that don't share it, is that a board of directors meeting is when you are actually intending to make any decisions or actually making any decisions on behalf of the association, because the statute says that a board meeting occurs anytime a quorum of directors is meeting to conduct association business, or meeting and conducting association business. If your intent is explicitly not to conduct association business because you're just gathering facts, my personal legal opinion is that that is not a board meeting. But understand that that personal opinion is not without some risk, because many attorneys will tell you, which means that some judges might also tell you, that a board meeting is anytime there's a quorum of the board even discussing association business. So I used to make an example of, if you're out at happy hour and 3 out of your 5 directors are meeting and they're talking about, well, we should throw a party using association funds, technically that's a board meeting. Okay, I don't necessarily personally agree with that, but that's what some attorneys will say. Now, the other things that you need to know about that board meeting are that the board having a meeting means that every member gets to attend that meeting unless there's an exception. Okay. Generally, every member gets to attend those meetings. And generally speaking, every member gets to speak at those meetings for up to 3 minutes on each agenda item, unless you've got rules and regulations governing that. Okay. Now, when I say unless there's an exception, the exception to the everyone can attend rule is if you're having a meeting with counsel to discuss potential or ongoing litigation. Keep in mind, potential or ongoing. So I've heard people saying, well, there's no lawsuit filed, so you don't get to meet with your attorney in a closed meeting. We get the right to attend. No, that's wrong. The other one is discussing personnel issues. So you're talking about employee salaries. That's not talking about changing salaries that a management company is paying to its employees. So this has to be personnel of the association. Keep in mind, even if you're allowed to have that closed meeting, the record of what those people are being paid or the decisions that were made by the association are still association official records and subject to inspection. The other thing I want to be clear on is that even though members are entitled to attend every meeting and know about what's going on, there's no such thing as sunshine law for condos. Okay, that's a government issue, and you are not the government. So if a municipal entity is meeting, the city, the county, the state, that's what sunshine law applies to. It doesn't apply to you as a board member of an HOA or a condo. Now there are alternatives to having a board meeting. One, you guys make the decision and you ratify it during the next meeting. That shouldn't be used as your replacement for every board meeting and make decisions all the time in between meetings, but it does allow you to hold the full conversation on something that you had to make a split-second decision on or an urgent decision on and make the decision formally at a later board meeting. The alternative to both of these is if you are communicating via email and you've got a consensus, you haven't voted via email because you're not allowed to do that, but you've made the decision and your bylaws and your articles don't say you can't do it this way, then Chapter 617 of the Florida statutes, the not-for-profit statute, actually allow you to adopt a unanimous written resolution of the board, which will fully replace holding a board meeting on that issue. So that is an option if you don't necessarily have the ability or the time to hold a board meeting. And I frequently see this coming up with, well, we only meet once a month. We meet every other month. We don't have a meeting coming up for 2 weeks, but we have to make a decision. Those are the types of things that these two options might be used for. I will never say they should be used for, but they might be used for that. You can't accept free stuff as a director. You're guilty until proven innocent. If you are found to have accepted those, free gifts, kickbacks are actually a misdemeanor in a condo at this point, and they are considering increasing that to a 3rd degree instead of, I believe it's now a 2nd degree misdemeanor. Also, if you're charged by information or indictment with felony theft or embezzlement involving association funds, you are removed from office. The vacancy is filled until the suspension is over. That suspension's only over if you are found not guilty or the charges are dropped.
Alan,
So
get that
just
water ready
understand.
because I'm going to ask you a quick question. So
Sure.
take a water break. Clarify, because this inevitably comes up every single time we do this. The accepting gifts, does that include the thing that even if it's $25 or less?
Well, keep in mind the 25 or less is generally an HOA concept, not a
Okay.
condo concept.
Okay.
And then the only exception really is the education. So if you
Right.
meet me and Jeff out at the condo and HOA
We were
Expo,
doing this at a live venue, for example.
right? If we were doing this live, then we would be allowed to give you some of our swag, so to speak, because it's part of an educational program.
Got it. Thanks. It comes up every time. Just wanted to clarify.
All right, thank you. Let's see. Moving forward, like I said, you get 48 hours, or the association gives 48 hours notice of every board meeting. It needs to be posted conspicuously on the property in a specific location, meaning the same place every time, that is designated by the board at least 48 continuous hours before the meeting. Now, if you're talking about non-emergency special assessments or amendments to rules regarding unit or parcel use, it doesn't say it here, but also amendments to your governing documents. All of those will require the same 14 days notice sent via mail or email as appropriate as what we talked about earlier for your annual meeting. It's still a board meeting, but it's going to require a different notice. You do need an agenda for every single meeting. It needs to specify what you intend to vote on, and anything that's not on the meeting notice can be taken up on an emergency basis by a vote of at least a majority plus one of the board members. Now, keep in mind, that emergency needs to be an actual emergency. It can't just be, well, we found out about this. We didn't put it on the agenda. We're not meeting for 3 months. It needs to be an actual emergency. And then that emergency action needs to be noticed and ratified at the next board meeting in the manner that we described earlier. So you're basically starting from scratch and having that discussion and having the vote. Notice of any condo board meeting at which regular or special assessments are considered needs to state that specifically the assessments will be considered, the estimated cost, and the description for the assessments. So what are we actually trying to levy assessments for? Is this just our budget and you provide a copy of the budget or notice that it's available? Or is this a special assessment that we're saying, listen, we didn't anticipate this expense. We have to be able to fund the expense. So here, you guys are going to have to pay that in addition to your existing assessments. If 20% of the voting interest petition the board to address an item of business, the board within 60 days after receipt of the petition must place the item on the agenda at its next board meeting or special board meeting called just to address that issue. Keep in mind, when members ask questions and try and force the association through the board to vote on something, they generally don't have the authority to do that unless 20% of the members have actually said to do it. So if you get a request from an owner and you're not sure how to handle it, you're not sure whether you have any obligation to even respond, run that by your attorney before you unilaterally decide, well, we want to be Mr. Nice Guy, because the reality is that owner is going to try and use that response as something that goes against the association. We talked about member participation at meetings and how you should have a policy governing that. Quorum at a board meeting is a majority of the board. You can attend those meetings via Zoom, via phone. You can't necessarily hold all board meetings via Zoom or phone, although the corporate act, the not-for-profit act, seems to imply that you probably can. Just be very careful with that. I would strongly suggest you get a written opinion of counsel before you decide to hold meetings that way. And again, for anyone that is hearing impaired or vision impaired, you might need to provide a physical location for that person or some other form of attendance for that person to be able to attend if they request the right to attend that way. Committee meetings are treated the same way as board meetings. If the committee is going to take final action on behalf of the board or make recommendations regarding the budget, those cannot be exempted. If there's anything else going on, generally speaking, you don't need to provide notice of a committee meeting. In other words, if you're not talking about the budget or recommendations being made to the board, you don't need to notice a committee meeting. Board conflicts of interest, we kind of went through. Again, I strongly suggest you check out our conflicts of interest class. And one thing that I usually don't do, but I think might be helpful, is going through how the board makes decisions. So first, you're going to have some kind of discussion as to what's going on, what you're even going to vote on. Then someone on your board is actually going to make a motion and say, I vote that we approve the representation agreement with K. Bender Rembaum to work with Alan Schwartzseid and the law firm because we think they'll do a great job. Okay. Second, someone has to second that motion. And then the board members get to discuss and vote on that motion. Now, the vote is either yes, no, or abstain. Abstentions should be specifically because you have a conflict of interest. It's not, well, I don't like what we're voting on, so I'm not going to vote. It's not, I'm sitting here with my arms crossed, angry because I don't like the other directors. You have a legal obligation to put your 2 cents in. I hate to put it that way, but that's the reality. And then however the vote is, that's what goes into the meeting minutes. Your meeting minutes, by the way, should not be a verbatim copy word for word of everything that was discussed. Motion, here's who made the motion. Here's who seconded the motion. Here's how the vote went. Here's how each member voted. And if it's unanimous, all in favor. That's it, done. So just understand, you shouldn't have a novel as your meeting minutes for every meeting. It should literally be bullet points other than the motion itself. There are a bunch of criminal penalties for forgery of ballot envelopes or voting certificates used in a condo election, theft or embezzlement of association funds, destruction or refusal to allow inspection or copying of official records, So these are all things that you will be charged with a criminal penalty if it's found that you've done any of these things. So just be careful. Also, as I mentioned earlier, if you are charged with one of these, you are removed from office and you don't get back on the board unless and until the charges are resolved without a finding of guilt. Other ways to get off the board: you resign in writing, you decide I'm done. Recalls, delinquent in the payment of any monetary obligation owed to the association greater than 90 days we talked about, criminal charges that we talked about, willing and knowing violation of the Condo Act. That's going to be, the division is going to remove you. So that's not the automatic. And the division can levy fines. That's the DBPR basically. And failure to satisfy the certification requirement, that's a suspension, not a removal. And then the final one is, if you die, you can't serve on the board. Moving on to budgets. Now, keep in mind what a budget is. Your budget is your best guess of what the association is going to need to properly operate and maintain the community over the course of the next year. You shouldn't be limiting what's in your budget, meaning you're reducing the assessments artificially so that you look good. You shouldn't be doing any of these things other than saying, here's what it's going to take to properly operate and maintain the community. If that means it goes up $1 million, that's what you should be adding to your budget, is $1 million. Now, I understand there's a law that says if your budget goes up 115%, it's a problem. But the reality is, I won't go into detail about that, but it's a completely misunderstood statute, and it requires that the members actually present and vote on an alternative budget. It's not that you're not allowed to present a budget that's more than 115% compared to last year. You have a fiduciary responsibility to include everything in the budget that should be in there. If the members decide later that they don't want to pay what they should be paying because they decided to water down the budget so they pay less, that's on them. You comply with your fiduciary responsibility in making sure that your budget actually does it right. The other thing I'll point out is that throughout the course of the year, if you end up at the end of the year spending almost exactly what you put in the budget at the beginning of the year, chances are you screwed up because you're backing into your budget. You're basically saying, well, this is what we had the money for that we thought we would need. Even though we needed to do all these things, we're going to breach our fiduciary responsibility by not doing things the association needs because we didn't budget for it. If you need a special assessment, if you need to amend the budget halfway through the year, if you can do that, those are things you need to do as a Florida Community Association board, as a Florida Community Association director. The other thing to keep in mind, when you screw up and you don't levy the budget to say, here's everything we reasonably think we need to properly operate and maintain the community throughout the course of the year, you've got a lot of people in Florida on fixed incomes that can't afford that special assessment that you'll end up having to pass. But they might be able to figure out, if you give them enough advance notice of, hey, this is what the budget's going to look like and what your assessment's going to look like next year, they can figure out either how to get the money together over the course of time, or that they need to get the heck out of Dodge because they can't afford to live there anymore. And I hate to be blunt like that, but the reality is the alternative is that you've got a bunch of owners who can't pay their assessments. You end up with a bunch of attorney's fees for collection and foreclosure. You end up with a bunch of units that have been sold at a lower price that deteriorates your property values. And you end up with a bunch of bad debt that mortgages are going to foreclose out, and you're not going to end up getting paid nearly anything or anything at all for those pre-mortgage foreclosure assessments. So all you're doing is adding more by not being honest about this to the amount that every other owner that was paying their assessments now has to pay. And it becomes this vicious cycle that you do not want to get your association into. So that was a soapbox that I will step off of now, but it's very important to understand you need to properly operate and maintain your community, and you need to actually allow your community to do what it needs to do. So moving forward, these are just things that your budget needs to include. I'm going to skip some of this, and frankly, I'm going to have to skip entire sections today because we just don't have the time for it. I can skip up to 3 to 4 sections without impacting your ability to get the credit that you need. So don't worry about that. Again, if you got questions, reach out to me. Your budget gets adopted by providing 14 days notice because this is an assessment. And you basically provide that notice with a copy of the proposed annual budget attached. Then you have your meeting, board gets to vote. Now, keep in mind, this is not the members voting. unless they are voting on an alternative budget. It is the board deciding what goes into this budget. So it is a board meeting that you are going to hold to adopt the budget. The board adopts it at least 14 days prior to the start of the association's fiscal year. That's so that you can give everyone notice of what their assessments will be next year. So that makes sense. If you don't adopt the budget a second time, that's a minor violation, and the prior year's budget continues in effect until the new budget's adopted. Basically a some harm, no foul. I don't know how else to put that. I won't go through reserve terms because these are really just statutory and legal terms, but I will go through what reserves are and some of the stuff that is required now, because that's one of the major issues that a lot of communities are facing right now is these mandatory reserves. So before, it was the budget must include reserve accounts for capital expenditures and deferred maintenance, including but not limited to roof replacement, building painting, pavement resurfacing, and anything that the deferred maintenance expense or replacement cost exceeds 10 grand. Now, the reserves now are about 10 other things that pertain to the structure of your building that have been added to these mandatory reserves. The difference is, as of, looks like, within the next year or two, the association will have zero authority, even with a member vote of 100% of the members, to waive those reserves. They are statutorily required, end of story, period. So just understand that, you can, we've done, I think, probably between myself, my partners, Mike Bender and Jeff Rembaum, and maybe one or two others within the firm, we've probably done 10 to 15 webinars, all of which are available on our website, pertaining to structural integrity reserves and all of the other things that go along with that. I would check out Rembaum's Roundup. Jeff, if you can share the legal update that Jeff did this year, that's a fantastic article that'll go through a lot of the required maintenance, a lot of the required studies for reserves to figure out what you're supposed to really be putting away.
Put
So
that
Jeff,
into the chat now for everybody.
chat, that'd be great. Now, moving along to what reserves actually are, now that I've been talking about them for 5 minutes, this is literally just money that you're putting away to save for, I would say, a rainy day, but in reality, you're saving it for a particular asset. When that asset is expected to fail, require severe maintenance, that's less than a once per year type of deal. And thank you, Jeff, for adding that into the chat. So the link that Jeff provided, just check out the roundup. The legal banner, like Jeff mentioned, is at the top. That's the article that I'm talking about. So if you're in the webinar right now, go ahead and click on that and save it for later, because I think it's a fantastic article. But the reserves are just money that's being put away for when a reserve asset is expected to basically die or require significant repairs. Okay, so what you're doing in a straight line reserve is basically taking all of the mandatory items that you're supposed to be saving, which are either statutory or they might be directly in your declaration, and you're putting the money aside to basically have money available when you need it. So instead of just putting in your assessment, well, we think we're going to need to replace this, so we're going to have a special assessment of $100,000, you're putting aside some money every year so that you have that money when this thing dies. Now, the reason that these statutes were changed, I'll just get into minimal detail, but I'm sure everyone that's on this webinar has heard about the building collapse in Surfside, Florida a couple years ago. There's been legislation over the last 2 years. There are changes that are being proposed this year to that legislation, but all of it requires certain studies to be done to check the structural integrity of your important components of your building and to verify that, frankly, this is a safe place to live or a safe place to visit. It's not, the building's not going to collapse. Things aren't going to fall off of the building, etc. So let me see. I think computing reserves. Yes, that's next. Okay. So what we're doing is essentially taking whatever it's going to cost to do the repair or replacement that we're going to need, figuring out, hopefully through a reserve study, how long we have before that happens, basically having an expert come out and take a look. That's going to be either an engineer, an architect, or someone who does that type of work, like a roofer checking the roof, someone who does paving, checking your pavement outside, etc., and determining how long do we have before that repair or replacement is needed. For a straight line reserve, you're literally taking the estimated useful life So let's say that's $100,000 roof. It's expected to last 10 years, and you're dividing that into each other. So we're taking the $100,000 clubhouse roof, dividing it by 10 years that it's supposed to last. It's a really cheap roof. You shouldn't be using that one, but that means that you're saving $10,000 each year. Okay, because $10,000 over 10 years will cover your full 100,000. But there's going to be inflation. There are going to be other factors that change the cost of that work by the time that you're actually getting the work done. So eventually, over time, you're going to get a reserve study done to check on whether those figures are still accurate. Now, you might find that it's more or less than you originally got an estimate. Let's say that roof now is going to cost $110,000. Well, all you're going to do is put aside the additional money for the rest of the years you have left. This is straight line. Now, the pooling method, let me see, I think we have, waiving or reducing is drastically changed. I would strongly suggest you watch one of our structural integrity reserve study webinars to get more information on this, because I just don't have time to go through all of it in depth today. But you're welcome to shoot me emails with questions about this stuff. Pooled basically means that the association has one account to cover multiple categories of reserves. So you might pool together, and there's a question as to whether you can do this, but you might pool together all of the reserves for all those mandatory items. What the pooling does is allows you to put together the money that you think you'll need at any given time, instead of putting together money that is, okay, well, we're going to save for this, we're going to save for this, we're going to save for this. And for a long time, you've got a bunch of money just sitting around waiting to be used in 15 years. So, pardon me, the pooled method tends to result in lower savings, so to speak, and it tends to result in an easier path for the association to put that money away. Whether or not you can do that as to any of these individual reserves to combine them together into that pool, it hasn't really been decided yet. So just keep in mind, you can use the pooled method. Whether you can use that for these new mandatory reserves, I think you should be able to, but until we get a legislative clarification, it's not entirely clear, and you're taking a little bit of risk if you do it. As of now, the association can waive reserves, reduce reserves, or use reserves for another purpose by having a majority of the members vote to use those funds differently. But generally speaking, if you have a reserve in a pool, you can only use the funds for something, one of the assets that's in that pool. If you've got a straight line reserve, the funds can only be used to repair, replace, etc., work on that particular asset. So you're putting away money for something specific to be repaired or replaced at a later date. And that later date is going to be at least more than a year down the road. Limited proxy disclosures. We have a specific disclosure that's required if you're not putting away that money for reserves, that basically you're going to need a huge special assessment that no one's going to know about in advance other than the people that are not putting the money away. So this is just something that must go into the proxy ballot if you are going to decide whether to waive or reduce your reserves or use them for different purposes. Basically notifying everyone, hey, by voting in favor of this, you might get a huge special assessment in the future. Financial reports, the members are entitled to copies of all association financials. And frankly, this is an issue that you're going to want to deal mostly with your accountant on. But I will go through it very briefly. You've got 90 days after the end of the fiscal year or annually on a date provided in the bylaws to prepare and complete a financial report. If you have someone that's compiling and preparing that for you, you have 120 days instead. Now, once that's done, the association must mail or hand deliver to each unit owner a copy of the most recent financial report, or what most communities will do in my experience is provide notice that a copy is available, because that's a one-page document instead of a bunch of multiple-page financials. That'll be provided within 5 business days upon receipt of a written request. In other words, it's not the standard 10 business days for a records inspection request to produce these financials. It's 5. So just be careful as to when you're producing these. Frankly, most communities are going to have them up behind login credentials on the association website by now. It's 2024. If you're not doing that, it's something to consider. You need to provide an annual report to the department containing the names of all the financial institutions which you maintain accounts. Copy of the report can be obtained from the department upon request of any association member. This is just, again, financial reporting. Here are the levels of what you actually need. And normally I would go through them, but we're already at 3:40 and we only have less than an hour left and 100 slides to finish. So we're going to skip that. But just understand, the more money you have, the more complicated and the more detailed your financial statements will need to be. Here in this slide are the actual criteria. Here's just a bunch of things that board members should know. These are issues that if you're not really sure how to deal with them, you really need to contact counsel. Meeting minutes, again, I already talked about how they should be very short, very clear, and succinct. Return of condo association records and property. Anyone that comes off the board and off a committee must return all association property within 5 days after the new board or committee members are appointed or elected. Meaning, if you are holding on to association records and the association doesn't have copies, you need to get that back to the association now if you're no longer on the board. Anyone that willfully and knowingly fails to return those records are subject to penalties by the Division of Florida Condominiums, Timeshares, and Mobile Homes. In other words, you're getting penalized if you don't produce those records to the association that are actually association property. Frankly, that's essentially civil theft, in my opinion. And that is something that is coming down the pike as a potential change, that this will be a crime instead of being just a civil penalty to some extent. So moving forward, access to units. Association has access to make emergency repairs that are necessary to prevent damage to the common elements, the unit, or to adjoining units. This is not a, well, you need to provide 5 days notice and this and that. This is not self-help. What we're talking about is preventing emergency problems. So you're coming in, I had one recently where a unit owner was hoarding. They had rat infestations and cockroach infestations in their unit, and it was starting to shift over to adjacent units. The association had an absolute right to enter into that unit and clear out the situation because the owner failed and refused to do so. Water leaks are another one that'll definitely be sufficient to justify the association entering into a unit. We can go through a laundry list of opportunities for the association to have to enter a unit. Another one is if the unit is abandoned. There is a statutory definition of abandoned. The unit can be inspected along with the adjoining common elements in an abandoned unit. Necessary repairs can be made. For example, if there's no functional AC, that's something the association can turn on to avoid mold, things of that nature. You can adopt rules and regulations. I mentioned you need to give 14 days notice before those are adopted at a board meeting, but the board does generally get to adopt those rules without a member vote. The rules can't conflict expressly or by implication with any language of the declaration, articles, or bylaws. For that reason, among many others, I strongly recommend that before you adopt any policies, rules, regulations, or if you're in a community that might actually adopt them, even though you're a condo, architectural criteria, those should all be run by council to make sure that there's no conflict and that what you're adopting is actually going to be enforceable. What you might also not know are what the Florida case law has basically said you can't have in your rules and regulations, and what the statutes have also said the same thing about. The association has the obligation to maintain the condominium, including keeping the common elements in a state of good condition and repair, replace portions when necessary, etc. When we talk about material alterations of common elements, the association generally doesn't have the right to change the appearance of anything on the exterior of a unit unless there is a 75% vote of the voting interests, or the declaration says that the vote is a different percentage. Now, there's an exception to that, where if the association is making alterations and the governing documents require unit owner approval, but the improvement is going to reasonably protect a common element, protect the association, that member vote is not required, even if it changes the appearance. So in the Tiffany Plaza case that is well known in the condo world and in HOA world, this was a rock revetment wall. It's one of those where you have rocks that are screening so that water doesn't flow from a waterway onto the sidewalk or the places where people are driving. So it's to improve and protect. Then it's a material alteration still, but it doesn't require a member vote. So we've got, again, cases where we've talked about this. I won't go through them in detail. Another thing that I'm going to have to skip is the emergency powers. Just know that the association has certain authority that doesn't exist under Florida law, except when there is a declared state of emergency in the area where you reside. Now, these are powers that were clarified a little better in 2021 when it wasn't just a hurricane that we were expecting to hit, but it was also COVID that was going to cause injury or damage was anticipated in connection with the emergency. So that is now the standard. If you anticipate that injury is going to be caused or damage is going to be caused by the thing for which a state of emergency has been declared, then you have these emergency powers kick in. Again, I just don't have time to go through what all of them are, but you've got the power, you've got the slides here. There's literally only one statute for you to look at, and it is a very clear list of the powers that you have. If you have any questions on it, feel welcome to reach out, but I'm just going to skip through it because it's a couple slides that, frankly, we just don't have the time for today. This emergency kit I do find important enough to mention. You want to have pen and paper whenever there's a hurricane coming or something that might impact the power and the safety of your condo. Pen and paper available, a disposable camera so that you're not relying on the batteries in your cell phone, which might be more important to use for phone calls and text messaging and internet at that point. Walkie-talkies, again, same purpose here. You got the batteries that will power those walkie-talkies, and you can communicate with the other directors in the building. Important vendor contact information printed out. And another thing that I'll mention along the lines of, well, what if the battery dies on your phone or your laptop? You'll want to have a large external battery. I have one that's like this big. I think it's like 15 pounds. It's insane. And it cost me about $100, but you know what? I know that if there's a hurricane, my cell phone's going to last 5 or 6 days. So that's the type of stuff that you want to make sure you have available. Leasing approval and amendments is another one. We have an entire class on it, but for now, I will mention that the grounds for disapproval may include, and this is again only, well, not again, but this is only if you have the right in your declaration to approve or reject leases. But the grounds for doing so may include a unit owner being delinquent in payment of an assessment at the time the approval is sought. Meaning, if you've got lease approval rights in your declaration, you don't even need to get the application in. You can just reject the request if they're delinquent in payment. You probably want to let them know, hey, you're being rejected because you're delinquent. Here's a copy of your ledger, or please contact the attorney at, whatever the phone number or email address is. But you do have the right to reject it on that basis. New leasing restrictions and rules must be in the declaration and will only apply to unit owners who vote in favor of the new leasing restrictions if they're adopted. So you might have different regulations that are applicable to different types of unit ownership, meaning if someone voted against that leasing regulation, then until that unit gets sold, that unit's not subject to the regulation. Now, that won't apply in a condo or an HOA context for certain amendments that pertain to short-term leasing. The legislature recognizes that some condos and some HOAs were just not intended as short-term leasing places. So there is some of that you might be able to adopt and have it apply across the board. My suggestion, if you're considering that type of amendment, you definitely want to work with your attorney on it. And whenever I say you want to work with your attorney, again, if you don't have one or you're not happy with them, please feel free to reach out to me. I can give very brief guidance that won't be legal advice, but might be educational. Or you never know, you might want to work with our firm for me to take care of the work anyway. Moving forward, if the declaration is silent, amendments require a 2/3 vote of the membership. That is not 2/3 of a quorum. That's 2/3 of everyone whose voting rights have not been suspended. Proposals to include the amendments, proposals to amend the governing documents must contain the full text of the amendment and use this format. If it's new language, it's underlined. If it's deleted, it's stricken. If by doing it that way, because there's so much that's being changed, it would not make any sense to the person that's reading that, you can actually just put the new language in there and ignore everything that was in there before and say substantial rewording of declaration, see provision, whatever, whatever that provision is that's being amended, for present text. Amendment to a governing document is effected when it's recorded in the county public records. Now, if you don't think you can get the vote for an amendment, another thing to mention is one of the things that I literally just got a request to do today is an amendment that you start with solely to reduce the vote that's required to pass future amendments. The other thing that might be really helpful that I mentioned earlier is adopting electronic voting and having the members have an easier time of voting. The only concern there is, again, you have to get them to respond in the first place to say, yes, I'll vote electronically. But that tends to be easier, especially in larger communities where your mailing cost is significant when you try and have people vote via, mailing something out, getting it back. The association can't hire an attorney who represents the management company of the association. So keep in mind, I don't really care who you're working with. We'll figure it out as to how to make sure things run smoothly. We work with a ton of management firms, but we don't represent any of them. And that's precisely because we don't want to have that conflict where they're the only one we can work with. We want to be able to help the association and help the management company in the best interest of our client, the association. So just understand, if someone is representing the management company, they can't also represent your condo. It's not really clear whether this allows the association's attorney to engage in efforts on behalf of the current management company in connection with indemnification requirements or, some kind of insurance coverage. In other words, if the association's governing documents say, we're going to take care of these people if they get sued, I candidly don't believe we'd be able to represent those individuals. Hopefully an insurance company would get involved there anyway. So again, distinction between who we represent, just associations. And when I say we, I mean, it should be every attorney that represents a condominium association doesn't also represent the management company. I'm going to skip the electric and natural gas vehicles because frankly, there's just a lot of it. And if you have questions about it, email me. I'm happy to respond. But disputes and things of that nature are probably more important. You're going to want, if you've got an option to go to arbitration or pre-suit mediation, do the mediation. Frankly, it's always going to be preferable because in mediation, and this is something I do on behalf of community associations that are not clients, but mediation, you get to make the decision of what the end game is. If you don't like the decision, then a judge gets to make it. In arbitration, the arbitrator is going to decide everything. In litigation, a judge is going to decide everything or a jury is going to decide everything. In mediation, the parties get to decide whether a settlement term is acceptable or not. If you don't settle, you take your chances in court. But I'll jump off the soapbox and just go through because we just don't have the time. But my covenant enforcement class, the firm's covenant enforcement classes, are really valuable in explaining why mediation is usually going to be the right way to go. Now, when the dispute is between a condo and an owner, note what I said there. I didn't say between a unit owner and another unit owner. If the dispute's between a unit owner and another unit owner, and it's not about discrimination, the association has no responsibility to get involved unless it's impacting common elements or multiple unit owners. So my opinion is, don't spend association funds to resolve a dispute between unit owners. All you're doing there is fighting somebody else's fight, spending money on behalf of that one unit owner, which doesn't necessarily benefit the condominium as a whole, which is your responsibility. Now, the association needs to uniformly enforce the governing documents, including the covenants, restrictions, the rules and regulations that you guys have adopted as an association. If you don't adopt that, you may be forfeiting the right to enforce that stuff in the future. Most of the defenses that pertain to enforcement of your covenants, meaning someone does something that's against the rules. Okay, most of the defenses to those types of claims are because someone didn't have a policy as an association of how you're going to deal with those disputes. And as a result, the association treated one person differently than they treated another person, or they waited too long to enforce the violation, etc. So if you have timely, uniform, consistent enforcement, there really shouldn't be any defense to any enforcement matter. And when I say enforcement, I mean you're trying to get someone to stop breaking the rules. Okay. There are certain disputes that go straight to court. Those, great, go forward with them. There are others where you need pre-suit mediation or pre-suit arbitration. Again, we're going to go with the mediation every time. These are covenant enforcement, use of or changes to the parcels or common elements, amendments to the declaration and other governing documents, meetings of the board and committees appointed by the board, membership meetings and not including elections, which are addressed by arbitration, and access to official records. Okay, all of these are going to be addressed by pre-suit mediation, meaning someone has to send an offer to participate in pre-suit mediation before filing a lawsuit. Now, the letter, this is pre-suit mediation procedure, the letter is good for 20 days, and it's a statutory form, but you have to fill out, here's what the dispute is, here's who the parties are, here's why what you are doing is a violation, etc. You send out that notice. The owner has 20 days to respond, agreeing to use one of the 5 mediators the association selected. And if they don't respond or they don't choose one of those 5, you can file your lawsuit seeking an injunction or whatever else your attorney finds appropriate. If they do respond, you hold a mediation, you try and get the thing settled. Okay, if they don't make the payment to the mediator or they don't agree to a mediation date, same thing. It's like they never responded to your letter and you move forward. So just understand you do need to send this notice. You don't need to settle at mediation, although it's generally preferred so that you don't have to spend a bunch of time and money and wait to get your remedy going through the litigation process. But this is the process that I prefer and most attorneys in Florida prefer over the non-binding, or binding arbitration that the DBPR would hold. So these are things that the division does have jurisdiction over: election irregularities, meaning election challenges, board recalls, failure to conduct meetings, official records inspections, requiring a unit owner to do something or not do something on their unit, improper changes to common areas or common elements. And then it's no longer mandatory, but it's optional to hold that non-binding arbitration. I always say, if you're going to have to go file a lawsuit after this anyway, I would much rather do the mediation where I get to decide the outcome rather than do non-binding arbitration, than have to appeal to the same court that I'd be filing the lawsuit in the first place. I'd much rather have a judge make this decision than have an arbitrator that's legally allowed to be arbitrary make that decision for my community instead. Condo arbitration doesn't apply to these types of disputes, which I won't go through, but just understand, take a quick look. The big one here is breach of fiduciary duty. A lot of owners will throw that in as an effort to avoid the need to send any pre-suit notice. So just be aware of that potential. If you get any kind of notice that demands action by the association, in reality, you should probably be running it by your attorney, unless you're willing to just do what's being asked. Now, when non-binding arbitration becomes binding is 30 days after, or 31 days after the decision is made. If you do it as binding arbitration instead of non-binding, which is an option now, to enforce a decision, in other words, the arbitration decision was made and the owner's not complying with the obligation to pay your attorney's fees and costs, or to actually do what they were required to do and stop causing problems in the community. Well, now you go to court. This is why I say it's easier and quicker to have one-day mediation, be done with it, and decide whether to move forward with a lawsuit, versus arbitration, which frankly, again, is somewhat unpredictable and can take up to, I've seen it up to 6 months. And sometimes it's even longer. So you're basically filing a lawsuit, going through a lawsuit procedure just with an arbitrator, even though it's a little bit abbreviated, and then hoping that the decision is right so that you can enforce it in court rather than having to appeal that decision in court. There are prevailing party fees. Judges, in my experience, are far more likely to grant your full fee than an arbitrator. The DBPR arbitrators are notorious for reducing attorney's fees. For example, I know my general hourly rate is $325 as of the date of recording this video. I would generally be awarded, despite having 15 years of experience in this field, about $225 to $250 an hour, meaning that what you're doing is winning the arbitration, getting your fees and costs awarded, and despite the arbitrator finding that everything you did was reasonable, everything that I did in the arbitration was meaningful and was something that was necessary to move that arbitration towards a victory, yeah, the association's not going to recover everything anyway. So my suggestion is make the decision yourself, go to mediation. Skipping this, prevailing party fees are only authorized by contract or statute. Again, you're rarely made whole, but in the covenant enforcement context and in these arbitrations and these lawsuits that we're talking about right now, that is something that the association would have an entitlement to recover. Only in the context of collecting assessments is the association automatically entitled to recover those fees and costs, regardless of whether arbitration or a lawsuit is filed. In any other circumstance, you only get those fees and costs back if you are actually awarded those charges. Now, again, that doesn't mean you can't amend your declaration to specify that for violations of the declaration, either by the association or by the owner, there's an automatic right of the association to recover those fees and costs. So again, that's an amendment that I am working on for several communities right now that I think will be beneficial for the association, if anything, as a negotiating point, where you can say, listen, I know we haven't filed a lawsuit yet. We're still entitled to every penny we've incurred in fees and costs. Association websites, this is one of the ones that I'm going to skip. Use a good vendor, work with your attorney. That's the end of the story. Okay, you only have to have an association website as a condo. Here it is. If you have 150 more units. Now, that doesn't matter if you have 20 buildings or one. It's throughout the condo, not throughout each building. So if you have 5 buildings, each unit has 30 units, then yes, 100% you need to have an association website according to the Florida statutes. Official records are something that we're actually in the process of developing a class for as well. But for now, I will skip this slide because here's what's important. Number 16 at the bottom, or actually number 14. All written records of the association, which are related to the operation of the association, are considered official records and need to be maintained. Okay, the association needs to maintain these for 7 years, except board certifications for 5, or however long the director is on the board, and election materials until the next election. So basically everything that is on paper, or frankly, even on the computer now, that pertains to the operation of the association is something that should be shoved into those official records. Now, there are some records that are not just for those 7 years now. They are technically from inception of the association. And these are the records that you need to keep forever. Okay, so I'm not going to go through them in detail because the bottom line is it's pretty much everything. Okay, you need to keep everything for eternity as of right now. Bids to be performed or for materials, equipment, or services are for at least 1 year, not 7 years. That's how long you keep it. Then you can have a written policy and follow the written policy that your attorney should be reviewing or preparing for you that says when you will discard or destroy those records. Renters can now copy and inspect the declaration, the bylaws, and the rules. So keep in mind, they are, just because they're not a member or their members' representation doesn't mean that this person isn't entitled to those records. There are records that are not accessible to the members. Attorney-client privilege and work product information until the proceedings are completed. And I disagree with that part. I think it's forever because it's still privileged and you never know when someone's going to raise a new claim. But that's what some people will argue. We can talk about that again if you want to shoot me an email if you're not understanding. Information regarding the lease, sale, or transfer of ownership of a unit, medical records, personnel records, and these all make sense because they're personal. Association passwords and software allowing for manipulation of data. So you're going to produce your PDF or your printout from QuickBooks rather than access to the actual QuickBooks data itself that you could be manipulating. Certain personal information of the owners, which the owners can choose to disclose. The written consent forms that the owners will basically say yes or no, you can disclose that information. And then good news for once, if you inadvertently disclose information that you're not supposed to be disclosing, not the end of the world, no harm, no foul. Attorney-client privilege, anything that is privileged, meaning that it was prepared in furtherance of or in preparation for a dispute with an individual or a corporation, is privileged and is not subject to disclosure, is not subject to the owners having a look at this. Okay, correspondence from the association lawyer remains privileged unless the board decides to waive the privilege. Notice what I said, the board, not any individual director, not any individual officer, not the president, not even the attorney. So if I have a communication with you and it's a privileged communication and you're a director of a client of our firm, I can't disclose that information. Technically, I can't disclose it even if a court tells me I must disclose it because it's privileged. Now, there are circumstances where we can get around that by having the judge do what's called an in-camera inspection and not getting anyone else involved in that inspection. But just understand, only the board gets to make a vote and decide to disclose this. Now, we're running very short on time for the 40 slides I have left, so I'm going to go very quickly. But basically, the official records can be requested for inspection and copying at any time. The association has 10 business days to produce those records for inspection. As of now, you only need to produce them for inspection in the manner that they're maintained. You can basically say, well, we keep them all on the website behind login credentials. Here you go. If you have any problem with this, let us know. It's questionable whether or not that's going to suffice, rather than saying, here, you can come inspect it on a computer at our office and we'll provide access to your login credentials in the office. If you keep those records on paper, you only have to keep them in boxes or however you want. As of now, and this is something the legislature is trying to change this year, you do not need to organize those documents, including pulling out or cherry picking things that the owner specifically requests. So if someone says, I want the 2023 financials, you can say, come on in and inspect the records and give 10 boxes worth of stuff. Now, the easier way to respond to that is obviously going to be just provide those financials. Not saying you can't do it that way. You're just not obligated to provide what the owner has cherry picked. You can charge the actual cost for preparing and furnishing the documents, the question and answer sheet, and year-end financials to those that request them, and charge reasonable expenses for copies of other association records. Generally, that's going to be for 25 pages or more. And it's going to be, if you've got actual management time, you can charge that expense too, up to, I think it's only 20 an hour. But anyway, that's something that you might want to consider if you are spending an inordinate amount of time responding to records inspection requests. The other thing, in addition to charging for those expenses, is I would strongly suggest you adopt rules regarding the frequency, time, location, notice, and manner of records inspection. Again, this is one of those 4 major policies that I recommend every community have. You can't require an owner to provide any purpose for the inspection. They're entitled to it, period. And they can't state a reason for the inspection. Again, they're entitled to it, period. If you don't provide those records within the 10 business days, just understand the owner is going to be entitled to minimum damages of $50 per calendar day up to 10 days. I call that the $500 gift that you don't ever want to give, in addition to any attorney's fees and costs that are incurred by that owner and any actual damages they incur by not having access to the records. I've never seen anyone have actual damages by not having access to those records, but you never know. Why take the risk? Just have the policy, follow the policy, comply with the policy. Now, there are some severe and draconian rules that the legislature is trying to put in place as to what happens when you don't produce these records on time and what records you need to keep about what records you provided. But I won't go into those until it might actually kick in. But just understand it's being passed around the legislature right now that there are going to be some really severe penalties for failure to follow through on this. The faxes and email addresses that are given to the association for purposes of providing electronic notice to the owners are not subject to disclosure, but there's no real penalty for the association inadvertently. Remember, I'm using that word inadvertently disclosing that information to someone else. Contracts and bids, everything according to the Florida Statute of Frauds needs to be in writing when it comes to a contract that's not being performed within a year for the purchase, lease, or renting of materials or equipment to be used by the association, and anything that's for providing services. All of those need to be in writing. Now, what the contract should also provide is what the parties' obligations are with specificity, meaning it's not just, well, we're going to muck 4 inches of your pond in the community. It's, well, we're going to use this equipment to come in on a day when, these conditions are met within this amount of time and muck between this and remove XYZ specifically from this, this lake or detention pond located in this area within the community defined as whatever. So you want specificity. doesn't need to be 50 pages long, but you want to at least be clear what the owners or what the vendor is supposed to be doing. You want the cost to be incurred for each service, not an estimate of, well, we're going to provide some services that pertain to painting and we're going to charge you some money. You want the frequency that the service is going to be performed, especially for landscapers, things of that nature that are ongoing contracts. That includes management. The minimum number of personnel that will be employed, what insurances, licensure, and everything else is required. And then you might want to also have whether attorneys' fees and costs are awardable and how that contract can be terminated. Is it month to month, or is it a 5-year contract that the association needs to actually find a legitimate substantive reason to terminate early without incurring some substantial penalties? So you want to make sure all that's clear, among a lot of other terms that should be going into every association contract. When it comes to bids, if the aggregate cost of that contract is more than 5% of the total annual budget, including reserves, which might be the bulk of your budget, you need to obtain competitive bids. Now, you don't need to do that for certain professionals. And if you have no one else in the entire area that does the work, in other words, there's one entity in the entire county that actually does the work you're looking for, you don't need to go elsewhere and continue looking down in, if you're in Orlando, you don't have to look in South Florida. If you're in South Florida, you don't have to look in Tallahassee for some vendor who's going to charge you thousands of dollars to drive down to your community. If you've got less than 10 units, you can opt out of bidding requirements if 2/3 of the unit owners vote to do so, which means you've basically got to get, 7 people to vote for it. Hopefully that's not something super complicated. I don't have time to get into bulk communication contracts. Just understand those can be canceled by the members by a member vote, but you only have one chance to do it. I literally just did an assessment and foreclosure class last week on Friday that I think will be up in the next day or two on our website. Strongly suggest you check that out because assessments, frankly, are the lifeblood of your community. They are how you fund the operation and maintenance that the board is obligated to do. So I hate to say it, but if we want to we've gotten through enough of the material that I'm legally allowed to skip the rest. And frankly, we've got classes on everything we've got left in the slides. So I want to provide that 15 minutes or so of time for Q&A. So Jeff, if you can jump in and get that started. While you do, I'm going to go through and just make sure there's nothing that is absolutely urgent that isn't covered in other classes that are electives offered on our website already that I haven't already covered.
Thank you, Alan. Great job. Folks, I'm going to just go over in a moment the evaluation process. I just put the link into the chat area.
For 1 second, because I did look through the rest of the slides. There are a couple of issues that I just want to hit on real quick. One of them is recalls, because that's something that I mentioned, but some people might not even know what that means. That is basically when you have a bunch of members voting together to say we want different people on the board in the middle of the year. That's not something that can be filed and requested more than or less than 60 days before an election or after an election. But throughout the rest of the year, that's the way to change who's on your board. It is something that the members need to get together and decide upon. If you get a recall petition as a board of directors, immediately get that to your attorney, because the bottom line is you only have 5 business days to decide whether there's some procedural reason to not certify the recall, meaning actually remove the director who was decided by the members should be removed. So that's just something I thought was really important to mention. And then when it comes to insurance, make sure that you have all of the insurances you need. That is one of the few very, very clear obligations of the board, is to make sure that the property is insured, the any damage that occurs on the condo property is insured, etc. There's not a lot else that is really crucial. The other thing that I will mention, because we weren't able to get to it, is if you have someone who requests an accommodation, meaning I want to break the rules, and they say it's because they have some physical or mental handicap, get that one to your attorney as well, because the bottom line is you could be responsible for huge attorney's fees and costs because of these fair housing and Americans with disability laws. And you might get yourself in a lot of trouble that you didn't even know was feasible. So
Yeah.
just be very careful is my strong suggestion.
Yeah. That makes sense. And thanks for clarifying and making sure you cover that, Alan. Appreciate that. So again, we'll go over the evaluation process one more time after Alan heads out, after we finish a few questions and answers. So folks, there's a little raising hand icon at the bottom of your Zoom interface. Just click it once. Clicking it over and over again will make it appear, disappear, appear, disappear. So just click it once, your hand will remain up, and I can see the order in which it's being done. So we're going to go in the order in which folks are raising hands. And we'll get to as many as we can in the next 10 minutes. So the first one is Mary. Mary, we just enabled your mic. Please unmute yourself and please ask your question on topic for Alan.
Alan, thanks for taking my question. I have a question regarding pooled reserves. My understanding is that there's a new Florida law that actually prohibits this. Is that true? My understanding is that instead of a pooled reserve, everything now has to be itemized.
So what you're talking about is specifically the structural integrity reserves, meaning the ones that pertain directly to the structure and the safety of your building that were adopted about 2 years ago. It's not an across the board, you can't have pooled reserves, but if you actually read, as a lawyer, you read through those new statutes as they were amended last year and as they're proposed this year, they aren't clear enough to actually allow for pooled reserves of those particular reserve items. So if you've got other reserves that are not statutorily required for that purpose, those can be pooled still. There's nothing that says you absolutely cannot have any pooled reserves in a condo. There's no law that says that. It's just that it's not clear enough from a lot of attorneys' perspectives, including my own, that if you're talking about pooling those structural integrity reserves, that you're allowed to do that. That's really what it comes down to.
Right. Thank you.
Sure.
Just realized I was muted. Thank you, Mary. Next is Stephen. And go ahead and unmute yourself. And ask your question on topic for Alan. Stephen, going once. Going twice. And Stephen, we're going to go to the next person for time's sake. Patricia, please unmute yourself and ask Alan your question.
Hi, thank you for this wonderful seminar today. Very informative. I do have a question. We're asking for a clarification on holding our board/member meetings via Zoom. Is it allowed?
The answer is it would appear that it is, but you're still going to have to. I'll put it this way. Whether it's allowed or not is not even in question if you have literally one person in a physical location that everyone else can come to. And then you have a computer where everyone else can see that, basically you have a room, you have one of your directors or your manager in that room, and everyone else is allowed to come to that room that doesn't want to attend via Zoom. Okay. That's fine, because all of the board members are allowed to attend via Zoom. All of the members are allowed to attend via Zoom. But if someone has a problem with it, you're not holding a purely virtual meeting. Now, that said, it would seem, and I'm not going to say 100% definitively, but it would seem that the corporate not-for-profit statute would allow you to hold it entirely virtually. But the safer bet for most attorneys in this practice area that don't seem to even understand that not-for-profit statute also applies would be to hold it where there's at least a physical location available to anyone who doesn't want to or doesn't have the ability to attend via Zoom.
Thanks for that clarification. Appreciate
You're very
that.
welcome.
Thanks, Patricia. And Stephen, we're going to try it one more time, okay? Stephen, can you unmute yourself and ask Alan your question? If we can't get you, I'm going to lower your hand and we're going to go to the next person. Going once. And you're going twice. And okay, we're going to move to the next person. Ed, please unmute yourself and stay on topic and ask Alan your question.
Yes, sir. All right. I just want to make sure you can hear me. Can you hear me?
We
can
can.
hear you. Yeah.
Okay. I'm having, and really it's not a question other than I'm having difficulty with the chat link. When I click the chat, it says it's disabled.
Right, that's because we're taking questions in the forum that you are in right now rather than taking any questions in the chat. So
I
if
think
you've
he
got a
means
question, feel free to ask it.
I think he means
No.
the link for the
No,
evaluation.
no. Yes, that's correct.
Is the chat showing up? I'll go over that. Just hang tight with us and I'll go over that again at the end. Okay.
Okay.
All right. Thanks, Al.
No problem. Very good. Thank you.
Thank you, sir. All right. Let's move on to Rex. Rex, and I think I emailed you earlier today, Rex. Welcome back. Unmute yourself and you can ask Alan your question. Going once. Rex, going twice. All right. We are going to move on to Nancy. Nancy, please unmute and ask your question.
Thank you. This has been very helpful. I just had a clarification on the committee meetings, so that if the board creates a committee who is assigned to work on a certain project, are there specific requirements of that committee as it relates to agendas and meeting minutes and so on and so forth? And also the membership of committees, are there supposed to be a certain number of board members versus owners and that kind of thing?
So there is no committee that requires a certain number of board members versus owners, except for your violations committee, which I mentioned earlier, that you cannot have anyone who's a director, officer, or manager, or any of their family members on that committee. But every other committee can be comprised however the association wants. For it to even be enacted might require more than just a board decision. That's something you'd have to discuss with council, depending on the wording of your particular declaration. And then when it comes to what notices would be required, like I mentioned, you would really only need to provide notice of that committee having a meeting if they're giving guidance to the board or making decisions for the, for the association. So let's say, for example, and I'm not using this as a selfish plug, but if you have a committee that is determining who your new council is going to be, that committee can be comprised of anyone that's involved in the association, presumably only the members, of course, and there is no legal obligation to have notice or have the members able to attend their meetings unless and until they're telling the board what their findings are.
Okay, thank you very much. That's very clear. Thank you.
Thank
All right.
you. Okay, we'll probably have time for a couple of more. We'll do two more at least. Teresa, please unmute yourself and you can ask your question. And please, again, keep it on topic.
Yes, thank you for the opportunity. I'd like to ask, my unit is under trust. Can I let my beneficiary attend the annual board election meeting if I gave my beneficiary the voting certificate?
If it's a trust and the beneficiary has a voting certificate, it would really depend on how your particular governing documents treat the trust. But chances are, and when I say how it would treat the trust, what I mean is there one individual that's allowed to vote on behalf of the trust, or does it have to be something that's designated in advance? The facts that you provided would include that type of designation, so I don't see why that would be problematic. But again, I don't have your specific governing documents in front of me to give you a concrete answer. My guess, as a legally educated individual, so that is not just throwing things at the wall and hoping it sticks, but my guess would be that yes, that would be something that would be permitted, to have the beneficiary designated as the person to vote and having them actually vote.
Yeah, I forgot to add, I'm not an owner of the unit. Is that okay?
I'm not sure what you mean by you're not an owner. You said it's owned in a trust and the beneficiary would be designated.
Yeah, I mean, the beneficiary is not the owner of the unit. It's just someone.
Well, that's fine. The trust would get to designate, presumably by having the trustee designate, but again, it depends on your governing documents, that trust as the owner would need to designate who is entitled to vote. So if you are not the individual that's entitled to make that designation and it's somebody else, then that person is who would need to sign the designation in order for the beneficiary to be able to vote.
Okay, thank you so much.
You're very welcome.
Thanks, Teresa. All right, let's go
I
for,
got time for one more, and I actually have to drive out to Melbourne after this. So
you have the meeting. So we'll do one more, and then folks, in the evaluation, you can type in a question there as well, and also ask for contact from Alan. As he mentioned, he does reply to everybody asking for a reply. So Frank, please go ahead and ask your question, unmute yourself, and keep it as much on topic as possible and as little, we don't want it to be too specific to your documents either, because we cannot answer those.
Perfect. Thank you, Alan. Quick question. If we have the same board rolling over to the next period, do they have to do the same board recertification again?
as of right now, no. So if they're still on the board and they haven't stepped off at any time, then there's no obligation to take the class again as of right now. I say that because there is a bill that's going through the process of potentially becoming a law right now, where if that became a law, there would be some continuing education requirement. As of right now, you only have to take this class or something like it, or sign that certificate one time during the entire time you're on the board.
Oh, okay, perfect. Thank you.
Thanks, Frank. And I'll tell you, I'm not the attorney on this call, but I recommend taking this class as often as you can, because we update them regularly, tongue twister there, to stay current with legislation that changes, as well as current industry trends. So it's always very good to take this course as a review, even if you have consecutive service on your boards. Would you agree with that?
I would. I mean, frankly, I'm not necessarily going to recommend you take it with any other law firm, but there are multiple attorneys within our firm, in fact, that teach this class. So you might want to take it with me this year, take it with someone else next year within the firm.
Right.
And again, we know that we're going to offer it either via Zoom or in person near you, and it'll be free.
Right.
It's a win-win, in my opinion, to have more education versus having less, and especially given the time constraints today, which usually will apply to the class, but applied especially when I have to drive an hour or so.
Yeah.
You know, I wanted to make sure that we got as much important information as possible. And while it's all important, you want to get as much information as you can. I do recommend, in addition to taking this class every year, that you do take some of our separate, we call them elective classes, so that you can get more education and more in-depth knowledge of the specific areas of law that we kind of touched on, and the ones that I didn't have time to touch on, that you'll still get the materials that are discussing after Jeff is done with his thing today and after you submit your survey. So
Well,
I am going to head out in a moment. Jeff, I'll turn it over to you, but I did first want to say thank you, everyone. We still have almost 100 people on the line after the Q&A. And I really, truly appreciate every one of you showing up today and hopefully paying attention. I really hope everyone learned something today. If you do have any questions, again, it's AS as in Sam at KB as in boy, rlegal.com, AS at KBR Legal. That's the easiest way to reach me. And I truly welcome everyone that's on the call today to reach out if you've got questions. I might not be able to answer them if they're document specific. I might need to run a conflict check before I answer them, but I will be happy to receive them and I'll respond as soon as I can. So Jeff, thanks as always for your help and great work as usual. And we'll talk soon.
Alan, drive safely, my friend. Take care.